Microphones are on. Recording has begun. Good evening. This is the July 2nd, 2025 regular meeting of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 4:04 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Member decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Chair Yankee, that completes my announcements.
Okay, thank you. Can you read item number 1?
Item number 1, call to order, roll call, and agenda changes. For absences, we have notification in advance of the absences of Member Maxine Anderson, Member Laura Stein, Member Jack Livingston.
Okay, and thank you. If you could call the roll.
Following the roll. Member Schmidt.
Present.
Member Schmidt, present. Member LaHood. Present. Member LaHood, present. Member Sugarman.
Present.
Member Sugarman, present. Member Kumar.
Present.
Member Kumar, present. Member Anderson, absent. Member Highland.
Present.
Member Highland, present. Member Pilpel.
Present.
Member Pilpel, present. Member Wolf, absent. Vice Chair Stein, absent. Chair Yankee.
Present.
Chair Yankee, present. 3 absences.
Okay, so we have 7 people, and that's a quorum. Administrator Peterson, do we have any agenda changes to discuss?
Yes, we have agenda changes.
Why don't we begin with the one regarding item number 9? Here's that one.
Item number 9, file number 25041. We have a request from respondent for a request for continuance, and petitioner has granted that request.
Okay, so members, because this request was made less than 5 business days before the meeting, we need to actually vote to grant this continuance and remove it from this agenda. As Administrator Peterson noted, the petitioner has agreed to this, so there's no dispute among either parties.
I'll make a motion to continue this item and remove it from the agenda.
Okay, so moved by Member LaHood to continue item number 9. Do we have a second for that?
Member Highland, second.
Second by Member Highland. Any public comment? Oh, Member Popel?
Just a question. How was this communicated?
Via email.
Okay. In the future, if it's after the agenda is posted, could we get copies of the email distributed so that we can see both the request and if there's a response with a concurrence? That would help. We can just have that in the room.
Administrator Peterson, could that be arranged in the future?
Yes, a hard copy can be arranged.
If you'd like, I could read this into the record if that would make you more comfortable, Member Popel.
I believe you. I believe what's been referenced.
Okay.
That's fine.
Okay, so we have a motion on the table, so let's go ahead and take public comment.
Anyone wishing to make public comment on the motion, please approach the podium if you're in the room. If you're in the online community, please raise your hand in the app or press *3. I'll give you a moment. We have no one approaching the podium, no one in the online community with their hand raised.
Okay, I'll go ahead and close public comment and let's take the vote on that.
Taking the vote on the motion. Member LaHood.
Aye.
Member LaHood, aye. Member Highland.
Aye.
Member Highland, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Pilpel.
Aye.
Member Pilpel, aye. Checking for Member Wolf. Member Wolf, absent. Members, Vice Chair Stein, absent. Chair Yankee.
Aye.
Chair Yankee, aye.
Although I just noted an error in what I said. Item number 9 is actually the consent agenda item that continue is actually item number 12. My mistake.
See, this is why I want to see.
Should we modify the motion then?
Yeah, we should probably do that, just to
Okay.
be clear.
As the maker of the motion, I would like to modify the motion to continue item number 12,
Yes, this is file, just to be clear, 23036.
file 23036, to continue.
No, my bad again. Sorry, that's
Probably
the new house.
rescind the motion and do a whole new motion.
Why don't we do that?
Okay.
Wait, it's 13.
I'm rescinding my original
Second
motion,
one, okay.
and I'm going to look at this and read it as I say it.
Yes,
I am making a motion
it's gonna be 13.
to continue item number 13, file number 25028, and remove it from this meeting's agenda.
That would be the right one, yes.
Seconded by Member Highland.
New public comment?
Sure.
Public comment? Anyone wishing to make public comment on this motion for item number 13, file number 25028? Please approach the podium or raise your hand in the app or press *3. We have no one in the queue.
And
Okay,
To be clear, I see that item number 9 was by the same petitioner, but that one is remaining.
that can
on the
remain.
agenda.
Yes,
It's
that one
on
can remain because
consent.
that's the consent one. That doesn't require their appearance,
Got it. Thank you.
but 13 did. That was the mistake I made.
And it's continued to the call of the chair.
Yes. I will do my best to schedule this for the next meeting. It's likely where we'll end up.
Calling the vote on the new motion. Member LaHood.
Aye.
Member LaHood, aye. Member Highland.
Aye.
Member Highland, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Kumar, aye. Member Anderson, absent. Member Pilpel.
Aye.
Member Pilpel, aye. Member Wolf. Absent. Vice Chair Stein, absent. Chair Yankee.
Aye.
Chair Yankee, aye. 7 ayes.
Okay, that motion passes. 13 will be removed from this agenda. Now, Administrator Peterson, if you could talk about 11 and 12.
Items 11 and 12. Item 11, file number 23020, file number 12. Item 12, file number 23036. We received notification in advance that petitioner Paul Neha would not be attending this evening.
So typically, what we would do is when the petitioner does not show up, we typically close the files. These were compliance ones that were referred back to us. I didn't know if we wanted to do that now or if we wanted to do that at perhaps 5 o'clock. But what I was trying to avoid is having to have the city person sit through an entire meeting only to find out the person wasn't showing up. So,
I think let's do it now.
okay. So we could go ahead. I think the motion here would be to close both file 23020 and 23036 for non-attendance by the petitioner. Member Phil?
To be clear, did Mr. Neha say that he was, and again, this is why I'm interested in seeing the communication. Did he indicate that he was not going to attend ever period on those two, or just that he was unavailable tonight?
He says, "Good morning, Ms. Peterson. Please note that I will not be able to attend the meeting, but I would like to receive a recording of the meeting or a transcript. Respectfully, Paul Neha."
I think he's under the impression that we are going to proceed without him. But
That's not how.
that's not how we do
we do
things.
it. Right.
Yeah.
But that is something that we have discussed. I realize that it's not now, just airing that we've discussed the possibility of evaluating complaints without certain parties present. I'm not suggesting that we do anything with that information. I'm just putting that out there.
Right, but this is a referral back on a compliance matter, not on the merits. So,
Okay.
and we chatted about this a bit for the related item last week. And perhaps in the future, if we can be careful on item 12, it's Neha.
Yeah. It's Administrator Pearson, if we could make sure his name's correct.
I would recommend that I think we should continue this to the next full task force hearing. But because he did not seem to say that he wanted to, or verify that he will attend the next hearing and not just close the case, because I think he's going to reopen it if he assumes that we're proceeding with it.
Yeah, it's unclear based on his
Yeah.
email if he intends to, which way he intends to do that. Again, this was sent on Tuesday, so typically if it is a request for a continuance, it would be beyond when we would typically grant a continuances. It was the day before. Notices went out very timely in this.
Then I suppose, I guess we could close it and then he can reopen it if he wants to proceed.
That's what I would probably be the best course of action, just to follow past procedure and what our procedures say.
I'm just checking the file number for a second. This is not the same file that we heard last week, right?
There are so many.
But these were heard on April 22nd by PAC.
So these are different ones.
Got it. Okay, right. Those were the 24, 022, 030, and 36. This is 23, 020, and 36. Got it. I'm open to go anyway. in this.
Okay. So does someone have a motion on this one?
Chair Yankee,
Yes.
I should have chimed in earlier, but we probably shouldn't take actions on these items until after 5 o'clock. Or you can say it's in your intention to take the action at 5 o'clock so people can leave. It's just on the agenda. It's listed as we want to act on these items until 5.
True. They come after the 5 o'clock. Yeah.
It could be. We could call, why don't we do this? I can call this one specific, I will call 11 and 12 at 5, the first thing after public comment.
Okay.
The other one was a continuance that both parties agreed to the
Right.
prior motion. So why don't we do that? Why don't I call 11 and 12 as soon as we finish
General public.
general public comment, which is item number 7. So I'll do that.
Thank you, Mr. Young.
Okay. Administrator Peterson, do we have any additional agenda changes?
We do not.
Okay. I think we can go ahead and move along then.
Do we need any further public
I
comment?
don't think we, no motion, so. Item number 2.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force regular meeting of June 4, 2025.
Okay, do we have a motion to approve or any edits to the set of meeting minutes? I will note that these were posted timely by administrator and were sent out to all the members, so there should have been plenty of time to make any requested edits and getting them back to our administrator. Do we need a few more minutes on this? Or-
I was not at the meeting.
Oh. Anyone else? Do we need more time? If not, do we have a motion? Okay, I will move to approve these meeting minutes.
Despite not having done my due diligence, I will second the motion.
Okay. Moved by Chair Yankee, seconded by Member Pilpel to approve the meeting minutes. Do we have any public comment?
Anyone wishing to make public comment on item 2, if you're in the room, please approach the podium. If you're online, raise your hand in the app or press *3. I'd like to add a reminder to members of the online community. Please do not try to contact us in the chat. We are not using that WebEx function because members of the community who are in the room with us cannot see it. We have no one wishing to make public comment.
Okay, go ahead and close public comment and we can move to a vote on that motion.
Taking the vote on item 2, Chair Yankee.
Aye.
Chair Yankee, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland.
Aye.
Member Highland, aye. Member Wolf, absent. Vice Chair Stein, aye.
Vice Chair Stein is not here.
Absent. 3 absent, 7 ayes.
Okay, that motion passes. Move on to item number 3.
Item number 3, approval of orders of determination. File number 23092, Zach Carnazes versus Mayor's Office on Disability. File number 24022, Paul Neha versus San Francisco Municipal Transportation Agency. File number 24030, Paul Neha versus San Francisco Municipal Transportation Agency. File number 24036, Paul Neha versus San Francisco Municipal Transportation Agency. File number 24060, Lou Barberini versus Police Commissioner Jesus Yanez. File number 24064, Matt Joseph versus CCSF Department of Building Inspection. And file number 25029, Madison Alvarado versus San Francisco Police Department.
Okay, do we have any edits to these or a motion to approve?
Just give me a second.
I have a couple of questions.
Sure, go ahead.
So I'm realizing now that, so Madison, who works for the public press, came before the task force. Is this, or this was a consent calendar?
This was a consent item, and I believe what we did on this one, if I recall, was this one was severed, and I believe we added an additional violation on top of what the committee found.
So it was severed. Madison did not appear before the task force, but a vote was taken at the full task force?
I believe, because it was consent, I believe Madison provided public comment, but then, yes, the full.
Okay. So if I had been here, I would have had to recuse myself.
Mhm.
So I need to file something on that.
That's a good question. To our DC.
We asked our DCA about that.
Member LaHood, I believe, has an employer-employee relationship with.
The petitioner on the item on the consent agenda, the order of determination for file number 25029.
However, Member LaHood was absent from that meeting.
Right.
For reasons not involving this particular, relationship. Does she still need to file recusal paperwork, even though she was absent because?
Use the mic.
You were absent for the entirety of that, correct?
Yes, but I was under the impression that based on the new law that I need to say that I would have, should I just write to ethics and say I would have recused myself had I been here, even though it wasn't actually a hearing on the matter, it was on the consent agenda?
I mean, it wouldn't hurt to do that, I guess.
Okay, I can do that. I also would like to note, I don't think this holds anything up, but for the two items on the consent agenda regarding Mr. Neha, that where there were recommendations for that MTA, it said the committee requests that MTA produce the transcripts, and maybe we don't get into this, but in any case, things did not go well on that at CAC, but also there's really no enforcement on that because it's a request. Do we still think that we should be putting things like that in orders of determination when there is no enforcement that can be done?
That was the motion, so I think it.
So we should leave it as.
I would leave it as is.
Okay.
Um,
Essentially, they don't think they need to and don't want to. And
it was adopted as a request.
it was adopted as a request, so we
That's
should
an
just leave it as is.
That's what I would
Okay,
recommend we do.
that's it.
So
Member Popel?
two follow-up items on that. First, on the NEHA matter, I think that the two things that we do in disposing of items is to determine whether or not there's a violation, and if there is, or in some cases where there isn't, to make either a specific order or a follow-up request to a department. And I think if we did not specify that in an OD and just left that in the minutes, it would be sort of stranded. And I think it is good practice, even if there is no current enforcement mechanism, to notate
It was
it.
documented that we were asking
Right.
that they consider doing this, and they've subsequently told us, no, we're not going to do that. Okay.
Understood, but I think the practice of documenting that both in the minutes and in an OD is still a good practice. We may revisit that in the future based on powers and duties.
Then I have no objection. I just
Okay.
wanted to raise what has happened in between this order being issued and our subsequent Compliance and Amendments Committee hearing.
Okay, good to
Okay.
know.
And then the other bit was on the Madison Alvarado question, and maybe this is to the Deputy City Attorney. If the only action that we're taking today is to approve the ODs, and we've already acted substantively on the matter, I'm thinking that in addition to the disclosure that Member LaHood made, that it's more of a ministerial act to just approve an OD. And I would suggest that Member LaHood can actually vote to approve the OD, which is just reflecting the action that we already took. It's
And
not a new action.
I'm not deliberating.
Right.
Yeah.
Does that make sense?
Yes, I think that's fine.
Okay. And whatever she's doing with the Ethics Commission on notification and disclosure, that's all well and good too.
Yes.
It's very clear that she did not participate in the substantive discussion of the item.
I think that's fine.
So unless there's anything further, and I didn't find anything further, I'm happy to move approval of the 1, 2, 3, 4, 5, 6, 7 listed ODs.
Okay, so motion by Member Popel to approve the ODs. Do we have a second?
Second.
Seconded by Member Sugarman. Seeing other hands, so I think we're good on discussion on this. Let's go ahead and open this up to public comment if there's any.
Taking public comment on item 3, approvals of orders of determination. If you're in the room, please approach the podium. If you're in the online community, please raise your hand in the app or press *3. We have no one in the queue.
Okay, we'll go ahead and close public comment and take a vote on that motion.
And I do think Member LaHood's disclosure should be noted in the minutes.
Yes.
I'm sorry, could I have a repeat of what's requested, please?
I just requested that Member LaHood's disclosure be noted in the minutes. Right, yes. Mhm.
Taking the vote, Member Pilpel,
Aye.
Member Pilpel, aye. Member Sugarman,
Aye.
Member Sugarman, aye. Member Schmidt,
Aye.
Member Schmidt, aye. Member LaHood,
Aye.
Member LaHood, aye. Member Kumar,
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland, Member Highland, aye. Member Wolf, Member Wolf, absent. Vice Chair Stein, absent. Chair Yankee,
Aye.
Chair Yankee, aye. 3 absent, 7 ayes.
Okay, that motion passes. Let's move on to item number 4.
Item number 4, report on Ethics Commission show cause hearing. Presentation and discussion of actions taken at the Ethics Commission's show cause hearing for Sunshine Ordinance Task Force, file number 24021, Matthew Lataki versus San Francisco Police Department.
Okay, so the Ethics Commission at their last meeting held a show cause hearing for our referral of this file number. We authorized Member Schmidt to represent us. So I'll turn it over to him, and I believe Member Pilpel listened as a member of the public as well, so he may have some additional input. So I'll turn it over to Member Schmidt.
Okay, first, a mea culpa. I elected to make this appearance remotely, and I found out that that was a mistake. I had a new laptop and I could not get the audio to work. So what occurred, and I know Member Pilpel was present in the hearing, is that I ended up watching the hearing, but I did not speak at my appointed time. I am still, I think I may have solved my audio problem, but the lesson I learned is do not make an appearance remotely unless it's an absolute necessity or if it's required. So that's my mistake that I'm not happy with myself about. However, I do not believe that what I had prepared, I really don't believe after seeing the hearing itself that I would have imparted much for purposes of the hearing. The Lataki matter is a matter where I'm pretty sure we didn't refer it over, but Lataki brought our finding of a non-willful violation to them.
We did vote to.
Did we send it over?
We did.
Okay, but it was non-willful.
Non-willful.
Okay. And so Mr. Lataki appeared. The weird twist there was that Mr. Lataki wanted to argue that it's a willful violation, despite the fact that we hadn't found that, which is fine. I don't have a problem with that. So it could have been considered by ethics as a non-willful, and it seems like it could be considered by ethics as a willful. My intention was to really sort of combine speaking to the Lataki matter with, and I didn't intend to treat it as a willful because I think we generally agreed that we didn't think that there was willfulness. So I didn't want to make an argument that I didn't feel comfortable with. But I did want to say that Lataki was a case that should be before the Ethics Commission under other provisions of their existing procedures. and to then tie it to the fact that this being item 10 on their calendar, they were about to consider item 11, which is a revamp of their own procedures with regards to everything sunshine. That's a matter that I think that fortunately, since I was basically muted during the whole hearing, Member Pilpel appeared. It spoke during public comment and seemed to be very helpful to the commissioners. I learned that the commissioners seem to be not really not decisive, not clear, not convinced as to the changes that are recommended to them by their staff. And if you look at the changes, they're pretty much, they almost eliminate any consideration of sunshine matters coming either from us or from a complainant. I think that and I guess ultimately the commission had a long discussion about different ways that this could be considered. Is it a non-willful? Are they supposed to enforce our order? Not sure. They seem to have something in their existing guidelines that says that they can enforce our order. Or how does this become, or if this is willful, what to do, basically. The commission talked about these things. There's primarily one commissioner who seems to speak mostly on these issues. The issue also came up as to how to define willful. And it did not seem that that was really something that no substance came in at the hearing on that, although the commissioners asked their city attorney to give advice on that. But they didn't make any decisions. They tabled Lataki, and so that's going to come up later. And they did not even go into item 11, and they put that into the future. So item 11 is still, unpresented, let's say. But having seen what I saw, I think that it could be that Member Yankee, it could be that Member Pilpel could be very convincing with them. And I myself, I believe that I intend to appear at the next Ethics Commission hearing. I don't know in what capacities. But I think that we could argue on several of these points. Ultimately, though, I think that our core wish, our core need is to preserve as much of the willful violation avenue before them. Partly because I think that the law is stronger on that one than on these other matters. I do think that their staff's recommendations have a lot of verbiage that I would want to attack. I think they do make some mistakes, some assumptions. They make statements that are unsupported. Generally, they do have a lot of things right, but I think some of the critical things, I think they do have them wrong. So that is, I believe, everything that I saw, I would certainly ask if Member Pilpel had any other impressions from this, because it was really a long discussion, and it seemed like there was not a lot of decisiveness going on with the commissioners, at least the ones that were actually involved. I'll end there.
Okay, and just so everyone knows, item number 5 is specifically related to those enforcement regulation changes that Member Schmidt discussed. So we can discuss that and consider if we want to take action that portion of it in item number 5. But I'll turn over to Member Pilpel to talk more about the show cause hearing portion of it for item number 4.
Thank you. Yes, I was able to participate. I've participated in a number of Ethics Commission meetings, many over the years, including some more recently. There was, in my opinion, some conflation of the issues involving the Lataki referral and the amendments to their enforcement regs that we're going to talk about as item 5. So I'm going to try to not talk about what their item 11, our item 5, and just stick to their item 10, our item 4 in this instance. There was further, in my view, a lot of confusion among the commissioners, some further lack of clarity among the staff, questions about procedure, substance, the legality. Their city attorney weighed in at a couple of points. There was a motion that seemed likely to pass that would have re-referred the matter back to us. And I think and believe that my testimony scuttled that idea. I basically argued that we've already acted on it, made our choice, and referred it to them as a non-willful matter. And I think I represented very clearly, and I hope accurately, that the main reason we found that it was non-willful is that we simply had a policy disagreement with the police department as to whether or not the disclosure of the map or location of the cameras was warranted. And we simply took the position that it was warranted and that the exemptions did not apply. And they took the position that there were exemptions that they could invoke and that they properly invoked them. And I think I represented that. And I hope there was no dispute about that. Where they seem fairly unclear about where they go with that and what their powers, what their current powers are and procedures are with regard to both willful and non-willful violations. And so they ended up continuing the matter, I believe, to their next meeting in July, as well as item 11, which did not get presented. So I am happy to attend online or in person to back up Chair Schmidt on this. I think that was a useful exercise in engaging with the staff to some degree, more so with the commission. And it was, I think, instructive to our issue of amendments about what a different allocation of powers and duties might be. And one of the things I don't want to forget is that the question of whether a department did not comply with an order of the task force, I think, is not the right way to look at it. It's whether the task force believed that a department did not comply with the ordinance. This is not form over substance. This is actually that we were referring what we believe to be a substantive violation of the ordinance, even if it is a policy disagreement. It's not over whether they didn't comply with an order. It's whether we believe that they did not comply with the ordinance. Is that fair?
I think that everything that Member Pelpel said is is accurate, and he did not overstate anything with the Ethics Commission, and I believe that the Ethics Commission was assisted on a couple points by his presence there. And so, yeah, I'm in agreement. I think that, to me, there's four different sort of avenues that we're looking at. One is that last one that Member Pilpel mentioned about enforcing our order. I think that's a weak one, but they do have in their existing regulations, they do talk about enforcing our order. I don't know exactly if that's something that we want to be sort of pushing on. I do, to me, the strongest, well, you know what, I'm getting into the next item. The two strongest items are the ones that, and I'll say this again in a moment, are the ones where the Ethics Commission is specifically mentioned in the Sunshine Ordinance. I'll stop there.
Okay. Anyone else have any thoughts, comments on item number 4? Nope. Okay, let's go ahead and take public comment on that, and then we'll move to item number 5, which will dive a little bit deeper into the changes that the Ethics Commission is proposing. So let's go ahead and open up public comment first.
Anyone wishing to make public comment on item 4, please approach the podium if you're in the room, or raise your hand in the app, or press *3 if you are online. We have no one in the queue.
Okay, we will close public comment on item number 4 and move to item number 5.
And once again, I'm happy to participate and support Chair Schmidt. Thank you.
Great. Thank you, Member Popel.
No action on it.
No, it's a discussion only item.
Item number 5, hearing on amendments to Ethics Commission enforcement regulations. Discuss and consider taking action to provide feedback on the Ethics Commission staff's proposed amendments to their enforcement regulations.
Okay, so for this item, the Ethics Commission has sent out a notice of proposed amendments to the Ethics Commission enforcement regulations to their interested persons list. Knowing they'd be doing this, you could see as part of the attachments for this file, I asked someone from the Ethics Commission staff to be here tonight so that they could discuss these changes that they're proposing, answer questions from the task force, maybe take back our concerns. You can see by the response, they declined that and asked us to speak if we had comments directly to the commissioners themselves. So just as a brief summary, and I'll probably then turn it back to Member Schmidt. There's a memo from BC Matthews, who's their director of enforcement, and that's at the top of the long attachment from ethics. And then if you scroll down further, you can see the exact changes in the regulations they're proposing. How this mainly affects us is it gets rid of any non-willful violations or non-willful referrals. So we would only be able to refer items over to ethics for an actual willful violation. That'd be under 6734. So essentially the part of the Sunshine Ordinance that's under 6735, they're declaring there's nothing they can do about it. I'll read it just so everyone knows. That's 6735D. It says any person may institute proceedings for enforcement and penalties under this act in any court of competent jurisdiction or before the Ethics Commission if enforcement action is not taken by a city or state official 40 days after a complaint is filed. So they're essentially saying that they will not be addressing that portion of the Sunshine Ordinance any longer. That would leave us just with the willful portion. Despite multiple meetings by me and I know Member Pilpel, we had requested a few things that I think reflected all of our opinions on the willful portion. I think number one was we felt that willful violations needed to be seen before the actual commissioners, just like under the current regulations that non-willful violations actually go to a show cause hearing, but willful violations are first handled by staff and can be dismissed by their staff before it ever goes in front of an actual appointed commissioner. Despite us asking for that multiple times, I see no changes in these enforcement regulations that actually puts any willful violations in front of the commissioners unless the staff agrees to forward that on. So they could still dismiss, like they did with our prior issue that we discussed a few meetings ago, and it never really gets any attention. So I think that's problematic with this. Number two, the other thing I think we kept pressing on was that we need a better definition of what the Ethics Commission feels a willful violation is, so that we can prepare our packets, our evidence more clearly, that we know the target that we're trying to reach. And they seem to agree when we are having discussions. But yet again, when I look at these posed changes, I don't see anything that better describes what willful violation is. So I think we're still going to have the same problem of having to just figure out what a willful violation is in their eyes. And because we do not get to see their investigation documents, nor do we receive any type of comprehensive report back from staff when they do close something, we can't even really learn and refine what it is they want from us. So I find, for a variety of reasons, these to be problematic. Like I said, number one, it really limits the type of enforcement action we can take, because it dismisses essentially 6735 out of the Sunshine Ordinance. And number two, it does nothing to bring our willful violation referrals in front of the commissioners or define what it is they're looking for when we send those over. So with that said, I'll turn it back over to Member Schmidt, because I think he had some additional comments.
Where to begin? I'll try to be not repetitive. I do see an opening here, and it's partly because the Ethics Commission, and I think Member Pelpel would know this a lot better than I would, but seems to have a decent amount of turnover. And so we've got a set of commissioners who, you know, they didn't make any of these calls back in the day. They have a staff, who knows how long the staff's been around, but the staff is recommending certain things to them. And these recommendations are all to eliminate various avenues of recourse. And of course, our position, I think, should be that every avenue of recourse we advocate for if it's legitimate, because that's our job as the Sunshine Ordinance Task Force. I believe that the reasoning here, they're relying on the charter, the language of the charter authorization for the Ethics Commission, and the charter authorizes them to deal with 4 areas that will be their sort of their charter jurisdiction. And I think that it's either explicit or implicit in what the staff has recommended, that what the charter authorizes the commission to do does not include sunshine. Therefore, they can't do sunshine. And so the logic is that you only get to do what the charter says you've got to do. And if you try to go anywhere else, you're outside of your purview. I think that's I get it, but I think I'd have to disagree with it, because I think that there's a better reading, which is that Ethics Commission it got certain jurisdiction through the charter, but the voters also, approved this ordinance and included specifically mention twice to the Ethics Commission. And so this is a sort of a second task that's sent over to the Ethics Commission. I don't know if necessarily I would read it that the first task somehow doesn't allow you to take on the second task. So I think that's an implicit problem. And I don't know if it seems to me that the existing regulations, which, they're fine, they're not great. And I don't know how much the Ethics Commission has followed those regulations or their staff. I think that they're based on a reading that allows the Ethics Commission to do sunshine. And I think it should be our position as a valid position that, yes, they should. And I think that's what we should assert. I think I would want to emphasize with them, certainly number one, the willful violations, 6734. I think that the 6735, I could see them maybe deciding they don't want to get involved. I think that the reasoning of the Ethics Commission staff on this is the problem is that they do a lot of editorializing in their recommendation, and they seem to also I'm not quite sure. There's a statement that the commission cannot impose administrative penalties and may only impose penalties for violation of the charter. But there's no site that necessarily helps with that except for the charter. And then there's a statement that the only remedies that the commission can follow with the Ethics Commission is to recommend that the elected official or department head be removed. Now, that, on the other hand, it is mentioned, but it's, to me, immediately dismissed. And they say, well, there's no practical means of enforcing such directive. And to me, it's like, well, so what? Make the directive. And if they don't follow it, they're in violation of your directive. And that to me is significant in itself. The more problematic language that I see is they mention basically, they seem to characterize sunshine matters, everything we do here, as minor or unintentional infractions. And so the staff, whoever on the staff wrote this, they have an impression that we're processing minor or unintentional infractions. And we know that's not true. And if you take that as being the basis for all these changes that they make, they're operating on assumptions that I think we certainly can easily tell the commissioners themselves are improper assumptions. They're improper editorializing by people in the staff. So I think that the staff is, and I think Chair Yankee and Member Pilpel brought this up before, they're trying to really narrowly construe here. And I think maybe what our opening is to talk to the commissioners personally and say, we disagree that this, we disagree with the staff, and on these specific points, we think the staff statements are wrong. And our experience has been that everything we send to you has been basically killed by the staff. And then what I will recommend, if, you know, I'm assuming that I'll go if it's okay with everyone else. I would mention the two cases that we brought last year, because I think they're stellar cases. One is the 50-year-old police records on the Zodiac killer and all the sequence of events which Chair Yankee wrote up. And then I think I wrote up the mayor's texts referral. And I'm going to say to the commissioners, do you want these? I'm going to tell you the facts of what we looked at. Do you want these to get bottled up by your staff and to have you never even see them because of the way these regulations are written? That's pretty much what my presentation would be with them. I certainly, you know, it would be great to have Member Pelpel clean up anything that, you know, I don't do right or that I exclude, et cetera. But I think we do have this opening, and I don't know if we're going to win on all the existing avenues, but I think we want to at least make them think about it.
Thank you, Member Schmidt. Did you want to go, Member Popel?
Yeah, I'm mindful of the time, but I think that this is worth discussing briefly. I think several things. Yes, Member Schmidt has got it about right. I may be the only person left on the planet that's got as much history with both this task force and the commission and all the intersecting regs and whatnot over the years. I think fundamentally what's proposed by their staff on page 51 to 53 of our packet largely guts the text, doesn't provide more clarity. If anything, it creates more ambiguity, and is not a good solution. And, you know, seems to me like it's roughly inconsistent with the interested persons meeting that Chair Yankee and I attended and the investment in that. I'm going to, and Madam Deputy City Attorney, I'm going to not get into Charter Section 15.105 and C 3.699-13 and what powers the Ethics Commission has with regard to other complaints and whether we're within that enforcement authority or different. But I think at a minimum, and this is important because it might end up in a letter or other communication from us to them, as long as, and Chair LaHood is listing as well, as long as we have the existing language in 67.34 and 67.35D, however ambiguous that language is, I think the Ethics Commission should have regulations that address both willful failure / willful violations and under 67.34 and enforcement proceedings under 67.35D. Whether we like the language or not is a different issue, but I think their regs need to address both of those. And if they want to say we're not going to address non-willful violations, if someone attempts to file it with them, they will buck it over to us. And if we send something to them alleging non-willful, they don't want to deal with it. Okay, that may be acceptable. It may not be great, but it may be acceptable unless it's in relation to 35D and enforcement proceedings, but it may be that they don't want to investigate or handle non-willful violations, okay? But regardless, we need more clarity on what constitutes willful, either as a violation or an allegation. And that's lacking here. And whatever penalties or remedies may exist or may attach need to be much more clear. And none of that is here. And so I have problems with their proposed rewrite of the regs. And I'm happy to support Chair Schmidt in whatever magical way I can do that. And I am thinking that a short written communication authorized by us and sent either prior to their July meeting, which is a week from Friday, or after that, because I suspect that both the Lataki matter and the presentation of these regs will be there, but I don't anticipate, unless they've consolidated it all, that they're going to act at their July meeting. So I think that'll just be a first presentation. And I think having a communication from us saying that we don't find their proposed rewrite to be helpful would actually be helpful. And finally, I am willing to engage in discussions directly with commissioners, but I thought it was premature to do that until we'd had a discussion here tonight, because I think they want to get into it, but I'm not sure that they get it. And I think they're being somewhat not well led by their staff. Other than that, I've got nothing further to say.
Okay, so members, so this is what we can do. We can either talk about what type of response we want to have, or it's 5:06. We can move on to complaints, think about this, and then kind of come back at the end of the meeting when we handle the rest of the portion and deal with it then. So do we want to continue now, or do we want to come back to this?
I think either way, we should probably take public comment, even though there's not a motion.
That's how we can take public comment. I'm assuming there eventually will be a motion on how we want to, but
But just in case there are
Sure.
people who are here early.
you're right,
not
right?
having
One,
it
yeah,
later.
so they don't miss
Yeah.
it. So why don't we do that? Why don't we, since we kind of laid it all out for the public about where we're at, let's go ahead and take public comments, see where that goes, and then we can decide if we want to finish up on this or move it to later in the meeting.
Anyone wishing to make public comment on item 5 regarding the ethics enforcement regulations, please approach the podium. If you're in the online community, please raise your hand in the app or press star 3. We have no one in the queue.
Okay, we'll go ahead and close public comment. I don't want to rush through this because I think how we respond is important, and I think there's a couple ways we could do it, and we have to consider that. And so I'd be inclined, if it's okay with everyone, to stop discussion on item number 5 from now and then come back to it when we're done with the complaints. Is that okay with everyone?
Yes.
Okay, so we'll finish up with item 5, and we'll also do item number 6 after complaints. But since it's 5:08, let's move on to our special order and move on to item number 7 first, which is public comment.
Item number 7, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force's jurisdiction, but not on today's agenda. If you're in the room, please approach the podium. If you're online, raise your hand in the app or press star 3. We have one person online.
Okay.
Hello, caller. Do you wish to make public comment on item 7?
Yeah, this is general public comment, correct?
Yes, that is correct.
Okay, hi, this is at Disability Activism SF. That's @ Disability Activism SF. I am a disability activist, and I also have a YouTube channel with that name. I'm calling in regards to a previous item that was heard by this task force, file number 24004. I've been trying to get a PDF document of the ruling for that, of the official decision that this task force made. This task force, unfortunately, had factually incorrect information and also did not discuss matters of the Brown Act that were related to this complaint, and ruled that public comment, that the public has no right to public comment at Mayor's Disability Council meetings. This is like really disappointing and really undemocratic. And except for the two commissioners, Commissioner Wolf and Kumar, who bravely spoke up in favor of public access, public comment, and our functioning democracy, really disappointed that the other 6 task force members did not. And I've yet to receive an order of determination clear order of determination, as well as my appeal rights. I want to request that my further cases with the MDC and MOD, including the one today, really be postponed, because there's no point in hearing cases about public access at the MDC when the previous ruling basically just said that public comment doesn't matter at all and that we have no right to it. So I'm very discouraged with this task force, and I'm very discouraged with even engaging in this process anymore after such a brazenly anti-democratic ruling. And that's my request. That's my share. Again, this is at Disability Activism SF. That's at sign Disability Activism SF. Thank you for taking my public comment. And again, thank you to Commissioners Wolf and Kumar, who did speak up for our democracy.
Thank you.
Do we have any other public commenters?
We have no one else in the queue.
Okay, we'll go ahead and close public comment as part of item number 7. And as we discussed earlier, let's now move to dispose of items 11 and 12, which is where again, this is where the petitioner said that he would not be coming to the meeting tonight. So maybe just to be safe, we see if Mr. Neha changed his mind and is somehow present in the online community.
Mr. Neha, if you have joined us, would you please raise your hand in the app or press *3? I'll give you a moment. We have no hands raised.
Okay, so for items number 11 and 12, why don't we do this? Just so they're formally called, as the agenda notes, I intended to call them together. So why don't you, Administrator Peterson, call items 11 and 12?
Item number 11, file number 23020. Complaint filed by Paul Neha against the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Sunshine Ordinance, Section 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner. Item number 12, file number 23036. Complaint filed by Paul Neha against the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a request for records in a timely and/or complete manner. On March 6, 2024, file number 23020 and file number 23036 were called and heard together. The task force found a violation of 67.27 by withholding records without justification and referred the matter to the Compliance and Amendments Committee if Mr. Neha informs the task force administrator within 5 business days that he has not received the records. On October 31, 2024, Mr. Neha notified the task force that 5 business days had passed and he had not received any documents from the SFMTA. On April 2nd, 2025, file numbers 23020 and 23036 were called and heard together by the Compliance and Amendments Committee, who referred the matter to the full task force, saying that the respondent had not produced the records or appeared before the Compliance and Amendments Committee.
Okay, so they've now been officially called. Here we are. The petitioner is not here.
You're from MTA?
Do we have anyone here from SFMTA?
If a representative from the SFMTA is present in the online community, please raise your hand in the app or press *3. We have no hands raised.
Okay, so we have no one here from the SFMTA either. I know the SFMTA representative was informed of Mr. Neha's statement that he would not be coming, so that could be why they decided not to show up either. Although I do know our administrator asked them to still appear, but nonetheless, here we are. So I think at this point, our procedures are pretty clear about that we typically close these for non-attendance.
let's be clear, on page 38 of item 12, for example, respondent's failure to appear will result in additional violations of the Sunshine Ordinance. Perhaps that's at our discretion. Petitioner's failure to appear without prior notice will result in the file being closed. Well, there was prior notice, so I'm not sure that we're bound by either of those. Other than the specific notice provided, what's the general rule on this? Close?
Well,
Is it a 7B? Is it where are we?
typically a 7B. There was not a request for a continuance. It was just, I'm not coming. If it was a request for a continuance and it was made less than 5 business days before, then the question before us would be, do we grant the continuance?
Right, there wasn't a request for
There was not.
continuous, and there was an assumption that we would continue to work on the case regardless, which we are not going to do.
Right. I think that it involves a cooperative effort
Yes.
among the parties, and it can't just be in our laps to deal with the petitioner now saying, I'm not being, I'm for this. So for those reasons, I would support that we close this case.
And then Ms. Peterson will notify Mr. Neha that it has been closed and what he may do
Right.
subsequently.
And copied MTA.
Yes, that's what I would suggest we do.
Why don't you move that?
Okay, so I will make a motion to close file number 23020 and 23036 for non-attendance by the petitioner, and request that the administrator notify both the petitioner and the respondent that the case has been closed.
Pursuant to a specified code section, or notify them that the case has been closed.
I think we could just say that the cases have been closed. Or we could say 7B. It's kind of an odd one where they typically use 7B when they just don't show up at all. And this one, they told us they weren't going to show up, but
I think what you stated is sufficient.
Yeah.
Due to non-attendance by petitioner and to notify both parties.
yeah. I mean, at this point, this is a little different too, because we've already fulfilled our duty to issue an order, which we've done. This is in the compliance stage. And so I don't think there's anything that in the Sunshine Ordinance that requires us to continue calling this file. We've done our statutory duty in this matter. So.
And for what it's worth, this is similar to other matters that we heard last week, for which I suspect we would get a remarkably similar response from MTA.
Yeah.
So
Okay.
I don't think it's plowing any new ground.
So that's the motion. Do I have a second for that?
Is there a second?
I'll second if no one else will.
Okay. So moved by me, seconded by member Pelpel to close these files. Any comments from the members? See any? Let's go ahead and move to public comment on that.
Anyone wishing to make public comment on items 11 and 12, if you're in the room, please approach the podium. If in the online community, please raise your hand in the app or press *3. There's no one in the queue.
Okay, we will close public comment and move to a vote on that motion. Wait. I think I see a hand.
Thank you. Hello, caller. Do you wish to make public comment on items 11 and 12?
Yes.
Thank you. 1 moment, please. 3 minutes?
3 minutes, yeah.
1 moment, please. Caller, your 3 minutes begins now.
Thank you. Hi, this is at Disability Activism SF. That's at @Disability Activism SF. Kindly request that the record reflect that as the commenter. And I think that the task force has done a swell job, a good job from my layman understanding of handling this matter. I just wanted to recommend that maybe the commission consider more clear language, because the general public, a lot of us, we're just volunteers, and this process can be really kind of legalese and very complex. And so, there are times when I've not been able to show up And I might think, well, okay, I gave notice. I told the task force I can't be there. And it might, it might just be well to have more information on the website that says, you have, this is the first time I've ever heard of the 5 days in advance a continuation request. And I don't even know what happens if that request is made, if the person doesn't show after making the request. Like, does that mean that they lose their case if the request is not granted? So yeah, I guess as a member of the public, I just wanted to highlight that there's a lot of questions I would have as to how to engage this commission in this process if there's a conflict that arises, a health emergency, a family emergency, something of that nature that would keep someone from attending. That said, it doesn't sound like this person, made the correct effort. But I just wanted to share that in case it would help inform future decision making for the task force. Thanks.
Member Sugarman?
Thank you.
Yes, this is Member Sugarman. I just wanted to make a brief comment because I've heard, and I encourage you to continue providing feedback to us. I do think it's helpful in how we structure our meetings and how we, process cases and hear people. Just a note, because I've heard this comment many times, to respond that we are also volunteers. And that's all.
Member LaHood?
Yes, even though we don't usually engage with things like this, I just want to tell the commenter that part of the reason we will close files like this is so that there's not a logjam for other cases, but we're also there. Our rules allow cases to be reopened. So should the petitioner come back to our administrator and say, actually, I did want to have those cases heard again, they can be reopened. So there are plenty of opportunities for that, but we don't want to leave a lot of open files because then we don't have time to hear new cases and make sure that people who are actively engaged with their cases, we want to make sure that those cases get heard.
Thank you. Okay, let's make sure we have no further public commenters on this item.
Thank you, caller. Again, if you'd like to make public comment and you're online, raise your hand in the app or press *3. And if you're in the room and wish to make public comment on item 11 or 12, please approach the podium. Excuse me, could you approach the podium so that we could answer your question?
No, I'm just, because the police commission answered it, so.
Oh, thank you. Item 11 or 12.
Thank you.
Thank you.
We have no one in the queue.
Okay, let's go ahead and close public comment and move to a vote on that motion.
I'm sorry, was there a second?
Member Popel was.
Thank you. Taking the vote on items 11 and 12, Chair Yankee.
Aye.
Chair Yankee, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland.
Aye.
Member Highland, aye. Member Wolf. Member Wolf, absent. Vice Chair Stein, absent. 3 absent, 7 ayes.
Okay, that motion passes. We've closed items 11 and 12. So just for everyone who may be tuning in, just to give you an idea of how the complaints will run now, we've finished making all those types of adjustments. We're going to hear the consent agenda next. That'll be items 8 and 9. We will move on to item number 10. Then it will be item 14 and then item 15. So those are the order in which we will hear the complaints this evening. So let's go ahead and have our administrator read the consent agenda into the record.
Item number 8, file number 25021, complaint
No.
file.
Hold on.
Wait.
The graph ahead of it.
The language under consent agenda.
It should start with yeah.
Yeah.
The Sunshine Ordinance Task Force shall review file numbers 25021 and 25041 to affirm the committee's findings regarding the Sunshine Ordinance Task Force's jurisdiction, violations of the Sunshine Ordinance, Brown Act, or California Public Records Act, and, if applicable, to issue an order of determination and refer matters to a committee for monitoring. The complainant and respondent are not required to attend this evening's meeting, July 2nd, 2025, of the Sunshine Ordinance Task Force, but may attend to provide testimony during the public comment period for this item related to the determinations listed below. Item 8, file number 25021, complaint filed by Stacy Smith against the San Francisco Public Library, San Francisco Police Department, and 911 Communications for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. On June 17, 2025, the Complaint Committee found that the task force has jurisdiction, that the requested records are public, and referred the matter to the task force consent agenda with a finding of no violation by the San Francisco Police, San Francisco Public Library, and finding that the San Francisco Police Department violated Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request received in December 2024 and responded to in April 2025. The committee finds no violation by 911 Communications/DEM and further recommends that the petitioner follow up with the police department and DEM regarding records requests. File number 25, item number 9, file number 25041. Complaint filed by Anne Marie against Pariah D. and the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Sunshine Ordinance, Section 67.5, for failing to hold open and public meetings, 67.10 sub B, for meeting in closed sessions on a non-permitted topic, and 67.11, for failing to state the statutory authority for the closed session.
Okay.
On June 17,
Oh, I'm sorry. Yeah, go ahead.
2025, the Complaint Committee voted to place file 25041 on the task force consent agenda by stipulation of the parties that the task force consider finding that respondents violated Administrative Code Sunshine Ordinance, Section 67.5, for failure to hold open and public meetings, 67.10 sub B, for meeting in closed session on a non-permitted topic, and 67.11 for failing to state the statutory authority for the closed session.
Okay. Thank you, Administrator Peterson. Briefly, did anyone from the Complaint Committee want to provide any feedback on these, or I think they just speak for themselves?
I don't have anything to add. Thank you.
Okay. Does any member request that either file be severed from the consent agenda? And if not, do we have a motion to approve the suggestions from the committee on both of these items? Member Papa?
I don't find a need to sever, but I just wanted to discuss both of them very briefly, and then I'm happy to move the consent agenda unless someone else is desirous of that. And I think we're, in part to Chair Schmidt, I think we're still sort of ironing out how consent agenda works and the clarity of the motions. The way I understand it, the first item, the Stacy Smith complaint, was against 3 different departments, and the recommendation was to find no violation as to 2 of the departments, and essentially a timeliness violation as to the 3rd, the police department. But it's not recommending that we do any specific follow-up. It was just more that that's kind of a finding of fact in a way. I didn't read any more or less than that. Does that sound about right, Chair Schmidt?
Yes.
Okay. Anyway,
I think,
I don't know that it's unclear, but I think the more clear that we can make these consent agenda recommendations, and in particular when there are multiple departments involved, it's just more clarity is good.
you had to be there.
This was the complicated one that in fact came to us first before we even sent it
Right.
to complaints because
Because it was,
doubled up.
yeah. I'm not disputing any of that.
Yeah.
I think this is probably the best that one could do, given all of that. Okay, so that's item 8. On item 9, I don't disagree. As I said several months ago, the last time we had a complaint about this, I continue to be uncomfortable with what I might describe as the number and severity of continuing violations. It's almost a pattern in practice at the fine arts museums. And regardless of what happens with commission streamlining, as long as the Fine Arts Museum's Board of Trustees is a city entity that's a board or commission under the Arts. Madam Deputy, can you help me for a second? Is it Article 7 of the charter that deals with arts? I think so.
I think so. I can check.
Okay. Anyway, under the applicable article of the charter, they are in fact subject to the Brown Act and the Sunshine Ordinance as relates to their meetings, and this continuing to stipulate or agree that they have made a number of violations or continue to is troublesome at a minimum. And I understand that our jurisdiction only goes so far, and I opined previously that maybe we should do something else about it. Perhaps we don't have that authority, but it just bugs me. And I hope that others are paying attention to this, and that this isn't just another, item on the list. I'm not currently persuaded that we need to refer this to ethics or do anything further, write a letter or any of that. I'm just noting that it's yet another, and whatever's going on over there, whoever's advising, however they're running the place, it doesn't seem okay. And if this were any other department or board or commission operating in this way, it would have risen to some level of what the heck is going on. And because it's the Fine Arts Museums, only a small number of people seem to care. It bugs me. That's all I've got to say on that.
Administrator Peterson,
Noting the presence of Member Wolf.
we'll call it 5:32. Welcome, Member Wolf.
Thank you. It's actually 5:29.
5:29 for the record. 5:29. Member Sugarman, go ahead.
Just to Member Pilpel, what do you propose that we do?
I don't have a solution. I would prefer that their board be properly advised, trained, and I don't know, comply with the ordinance, for example, and not, do things the way they do it and then agree later on that somebody caught them, and that's unfortunate. I don't have a solution right this second.
I don't want to belabor this discussion. I understand your concerns. I also find that this issue. I don't actually think that the people who are bringing things against the Fine Arts Museum consider them to be a small portion and consider it to be a light issue for them.
Agree.
And for me, we deal with all sorts of respondents, and some of them, many of them come to us and are like, well, we were confused by the process. There wasn't someone here that we was supposed to be doing this. We were overwhelmed by it, et cetera, et cetera, et cetera. And I find it more rare that we have a respondent that just appears at the meeting and admits culpability. And it's just like, well, we admit that we've done something wrong. And I also think that one of the first questions I had, and I've heard asked also from another new member, but also I feel is common, is what is the efficacy of the Sunshine Task Force in that way? Like if someone is saying that they've done something wrong, we've given them a violation, that's all that has been done, and they continue to give the violation. So there's that as well. And it may be, for me, I guess, now I'm rambling about it. I think that it's good that the Fine Arts Museum is still accepting responsibility for the problem, even though they continue to like create a violation with it. But I also see your point and wonder if there is just any action that you would like to take.
Let me continue to think about that. I'm not sure that there's anything on our agenda tonight that we
Sure.
need to do, but your point is well taken.
Yeah. And the other thing I'd bring up also, I think to your point, Member Sugarman, is that while the public records portion of the Sunshine Ordinance gives us the ability to issue orders, it seems that the writers of the Sunshine Ordinance got a little, I don't want to say sloppy, but didn't think it through as much on the open meetings part. We don't actually even have the authority to even issue an order on open meetings, which I think is something we absolutely have to consider when we talk about amendments, because of just the reasons you just pointed out. I think it's a shortcoming that restricts us even further to mainly just finding violations, and largely that's it. Maybe we can refer things, and as we kind of heard already, our options for referrals are becoming more and more limited. So I think these are all problems you have to consider when we.
Yeah, and I don't want to, I mean, as we were discussing earlier about referring things to ethics, but I mean, it does seem what Member Pilpil is saying, that probably a better solution, since they are a responding party, like they are responsive, and they do, like I say, they have a connection with the Sunshine Force, that perhaps something better to do with them aside from enforcement of action is just what Member Pilpil says, training, like actually talking to someone and saying, hey, by like a strongly worded letter that says, by the way, you keep coming on these things that you could be, complying with, since obviously, you're making an error and admitting to it.
I have Member Schmidt and then Member Wolf.
Thank you.
Yeah, on just to Member Pilpil, on the prior item, when I said you had to be there, I meant it in jest, because it was sort of a circus-like atmosphere, the hearing that we tried to figure out how to deal with. But on this matter, it seems that maybe this is one where, because we're seeing this same problem, well, if they started to name a department head, then maybe we can direct something toward the 67.34 at some point. But right now, I don't think Paris Dia is a department head. I don't think so.
Perea.
Oh, Perea, sorry. But that may be one of the few ways that we could do more.
Member Wolf?
Yeah, I just want to, I've mentioned this a few times over the years. I was invited to come and give a training to the Code Enforcement Committee of the Planning Commission, or the Planning Department. I'm not sure who it serves necessarily.
Or maybe
And upon preparing for that, they thought that they were a passive meeting body. And upon preparing for it, I found out that they are actually a policy body, because they were created by resolution of the commission itself. And so we went around the table and started reading the ordinance, and lo and behold, it became very clear to them who and what they are. And I think that experience, laid a very, interesting level of gravity with them. And even the DCA that represented the Planning Commission wasn't aware of it. So it became, very clear. I'm thinking if there might be some way to engage the fine arts folks in the same kind of way, to kind of bring to light exactly who and what they are and what they're supposed to be doing. That might put them a little more on notice than just a letter.
I don't want to belabor this further. I'm happy to, again, move the consent agenda to Member Sugarman. I will think about ways to deal with it. We've done a number of letters, strongly worded letters, more strongly worded letters. I am sensitive to the fact that it's an Article 7 arts entity, which has its own sort of unique colors and flavors. But I don't think anybody should be excused from this sort of thing. And, I'm not sure who their current deputy city attorney is. It could be Lauren Curry on the government team. But regardless, they should know. And it almost suggests to me, again, back to training, that we spend, and various of us have talked about all kinds of trainings recently. The city spends a fair amount of time on Form 700s, on training, whether it's ethics, sunshine, various other trainings. And yet the folks that kind of need certain types of training either aren't getting it, or if they're getting it, they aren't getting it. So somehow I think our training resources need to be more focused and targeted on the particular audience so that it's useful training that actually promotes compliance with the law, rather than just check off or let the thing run and 2 hours later you're all done and you file a form and blah, blah, blah. Because for me, that's just not working in a lot of ways. So maybe that's part of the big fix. And other than that, I will think about it. But with all of those comments made by a variety of us, I am happy to move the consent agenda as items 8 and 9 as presented. And I so move.
So motion by member Pelpel to accept the consent agenda and recommendations of the committee. Do we have a second?
Second.
Seconded by member Schmidt. Let's go ahead and open that up to public comment.
Persons wishing to make public comment on items 8 and 9, if you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one in the queue.
Okay, we'll go ahead and close public comment and take a vote on that motion.
And I'm sorry, the second was by whom?
Member Schmidt.
Taking the vote on items 8 and 9, member Pilpel.
Aye.
Member Pilpel, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland.
Aye.
Member Highland, aye. Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Stein, absent. Chair Yankee.
Aye.
Chair Yankee, aye. 2 absent, 8 ayes.
Okay, that motion passes and we've adopted the recommendations of the committees. We can now move on to item number 10.
Item number 10, file number 24004, complaint filed by Zach Carnazes against the Mayor's Office on Disability for violating Administrative Code Sunshine Ordinance, Section 67.7 Sub B, for failing to provide a description that is sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item, that he or she may have reason to attend the meeting or seek more information on that item. On June 17, 2025, the Complaint Committee found that these are public meetings under the jurisdiction of the task force and referred the matter to the full task force for consideration of a violation of Administrative Code Sunshine Ordinance, Section 67.7, for failing to provide an adequate description on the meeting calendar, or 67.4, related to a failure to provide notice of passive meetings and request that respondent provide a link to where the meetings are located prior to the task force meeting. We had received word that respondent would be present. I see Deborah Kaplan. Petitioner, Mr. Carnazes, are you present? And if so, please raise your hand in the app or press *3. Hello, caller, confirming that you are Mr. Carnazes.
Yes, I am, and I'm here and present.
Thank you. One moment, please, while I promote you to panelist. Respondent Debbie Kaplan has been promoted to panelist.
Okay, thank you, Administrator Peterson. Member Schmidt, did you want to give us a summary on this complaint?
Yes. The primary allegation is a 67.7 violation, and we had ruled on a nearly identical case that was mentioned earlier by the I think it was a petitioner during general public comment that because this is not a policy body, that the requirements of public comment that apply to policy bodies don't apply here. So 67.7 is not something that it can be violated with this body. We did in committee, though, take a look at the passive meeting requirements, and I think it's worth considering whether 67.4 was possibly violated due to basically just unavailability of the information with regard to the meeting. So we should also look at that. I think members, anything else on that?
No, not a lot. Just that what I recall is that this had come up. It feels like this website in particular had come up once or twice in my recollection. And so outside of the complaint itself, I had noted that the website was very it didn't have like a strong structure in terms of public meeting like agenda and public comment period, et cetera. That was kind of like when we were evaluating the case, what I had personally looked at a few times.
Okay. Thank you, everyone, for your feedback there. So let's go ahead and get started. We will start with the petitioner, who will have 5 minutes to present, followed by the respondent for 5 minutes. We will then proceed to questions if the members have any. Then we provide a 3-minute rebuttal period, starting with the respondent, ending with the petitioner, and then we'll have a time period for us to deliberate and form a motion on this. And that's how these will work for the remaining complaints. So with that said, I'll turn it over to our administrator to let Mr. Carnazes know when his 5 minutes begins.
Mr. Carnazes, are you ready?
Yes.
Your 5 minutes begins now.
Hi, this is Zach Carnazes. It's at Disability Activism SF. That's @ Disability Activism SF. That's all one word. If the record could please reflect that. I'm a disability activist and a human rights activist, and I fight for people's rights to attend public meetings and to give comment. Don't really have a horse in this race other than for disabled people to know when meetings are happening and be able to inform city bodies of access violations so that we can participate in our society. That's literally the only reason why I'm here. As I mentioned in public comment, there was a very distressing ruling by this task force recently, last month, that this is a quote unquote passive body, whatever that means, and that it would not need to comply with public comment laws and the Sunshine Task Force laws, at least some, if not all of them. It was very distressing and somewhat negates a lot of the complaints that I have before the task force. I have requested a formal decision letter for a couple weeks now that has not arrived yet. And I've also requested that this task force please postpone future hearings about public meetings and public comment access at the Mayor's Disability Council or the Mayor's Office on Disability which has a new name now. It's hard to follow all these things, but you know, I've made that request because what's the point, right? If our public comment access is being removed through a reinterpretation of the law, despite the fact that the Mayor's Disability Council was appointed by Mayor Willie Brown, and I have testimony to that effect, and despite the fact that the Brown Act is right there in the agenda, you know, it's like, what's the point, you know? So we can hear on this one particular issue, I guess. I mean, it's nice that the task force is taking time out to consider it. But I see that this task force is a body meant to, as an alternative to going to the courts, and I'm seeing very little alternative to going through the court process right now and through other measures to address the egregious violations all over our city for public comment access and disability access. I'm more interested in talking to lawyers at this point than addressing this body, because I don't think this body is doing their job correctly. I say that with great respect for the people, the commissioners that are doing their job, like Commissioner Kumar and Commissioner Wolf, who took a stance and respected what the law says. But yeah, I think honestly, hearing this right now is I don't know. I'm here. I don't know what else to say. Democracy is a good thing, folks. Public comment access, good thing. Why we're voting to take that away, I don't know. I'll just pass with that.
Thank you, Mr. Karnazes. Mr. Peterson, if you could let the respondent know when she has her 5 minutes.
Thank you, Mr. Karnazes. Ms. Kaplan, are you ready for your 5 minutes?
Yes, I am. Can you hear me?
Yes, we can hear you. Your time begins now.
Okay, thank you very much. I was present at the meeting of the committee that decides which complaints should go forward. And at that meeting, the focus was on section 67.4 regarding passive meetings. And what the Sunshine Ordinance requires regarding passive meetings is met by the Office on Disability and Accessibility. It requires that all gatherings of passive meetings shall be accessible to individuals upon inquiry and consistent with the facilities in which they occur. And while such gatherings need not be formally noticed, except on the city's website, they shall be disclosed upon inquiry by any member of the public, and any agenda made available. We actually do go beyond those requirements, those minimum requirements. In my reply comments, I did provide the link to the current MDC website where agendas for meetings are available by clicking the link for each meeting. In addition, ODA maintains a mailing list with over 600 email addresses, and for every meeting of the Mayor's Disability Council, a hold the date notice is sent out 2 weeks before that meeting, and then 1 week before a link to the full agenda is sent out. And Mr. Karnazes is a member of, is on that list and receives those notices. I believe he mentioned that in his comments. We believe that any problem that was experienced related to lack of information regarding one meeting was the result of Problems with migrating our website from one platform to another since that complaint was filed. Unfortunately, our website was migrated twice, or has been migrated twice. And every time a migration like that occurs from one web platform to another, it takes a while before everything is available and restored. It's like having a punch list and finding problems that need to get resolved. And so for that reason, it's very useful to us when people do let us know that something is not available. We did reply to Mr. Carnese's complaint and provided that explanation. And I can tell you, we certainly hope that we don't have to go through any more migrations of our website because it takes up a lot of staff time. But it's a decision that our office doesn't make. So we believe that our regular practices comply with the law, and it's our intention that they comply with the law and go beyond the requirements of passive meeting bodies. Thank you.
Thank you.
Okay. Thank you to both parties. Members, do we have any questions for either party?
I have a couple of.
Go ahead, Member Popel.
Yes, Member Pelpel here. I've got a couple of very quick questions to both sides. To Mr. Carneses, can you point us to any code citation or other evidence that might lead us to conclude that the Disability Council is other than a passive meeting body as defined in the ordinance?
Yeah, so I mean, a couple of things. One is it's never been defined as a passive meeting body. The first time that ever happened was a month ago, and considerable length was gone to define it that way. One of the parts of conversation with that was that the Mayor's Office on Disability was, if a body is not appointed by a mayor, then it's a passive body. That was one of the issues that was raised previously. And the Mayor's Disability Council was appointed by Mayor Willie Brown. Again, I have evidence to that fact. I'm happy to share it. I'm currently inquiring as to what the appeals process is for that decision to provide further evidence to that. And there's also, I mean, I think the Sunshine Ordinance, the Brown Act, which is not even discussed in these meetings, but is part of my complaints, speaks very clearly and very openly about its defense and support of public meetings access. And I think this body has gone to considerable lengths to try to split hairs, and not all members of the task force, but certainly a few of them.
Okay. Yes, you've said that. I was referring to the definition of meetings in section 67.3, specifically the current 67.3C that defines a passive meeting body. And, I will let you read that on your own. I don't think that there was any redefinition by this body or anyone else. And I'm hoping that you've had a chance to read the Office on Disability and Accessibility's responses to the task force starting on page 7 and page 69 of our packet. If you have
Again, the Brown Act is not being mentioned. You're not mentioning the Brown Act, which is actually a part of the agenda of the Disability Council, the Mayor's Disability Council.
And I believe that we discussed that last month and suggested to the Office on Disability and Accessibility to perhaps reword that in the future because it was confusing and because the Brown Act appears to not apply to meetings of the Disability Council because it is not a legislative body as defined in the Brown Act. All right, unless you have anything further to Ms. Kaplan, I have read your responses as I referenced on page 7 and 69. I tend to agree at this point that it is a passive meeting body. I guess my question was, since the multiple website migrations, can you just give us the most specific link to MDC at, I presume, the current HSA website or wherever it is, so that one can find it more easily than clicking around?
It's linked in the reply comments that the most recent comments that were filed for this hearing. And I can give me a minute. I can give you the URL. Hang on a second. So it is www.sf.gov/departments-mayors/disability. I'm sorry, not slash, mayors-disability-council.
Okay, thank you. And shall I assume that the discussion that we had last month, that you're going to make efforts to clarify in the future the references that we talked about?
Yes, definitely. Thank you.
Okay, thank you for your help.
Okay, Member Kumar. Is it a comment or a question, sir?
No, I've not yet. I have a comment to probably after.
Okay, we'll save that. Any other questions, or should we move to rebuttals? Okay, let's go ahead and move to rebuttals and see no further questions. We'll start with the respondent for 3 minutes and then the petitioner for 3 minutes.
Ms. Kaplan, are you ready for your 3 minutes?
I have no further comments.
Mr. Karnazes, thank you. Mr. Karnazes, are you ready for your 3 minutes?
Yes, I am.
Your time begins now.
Hi, this is Zach Karnazes at Disability Activism SF. That's @Disability Activism SF. I'm a disability rights activist and a human rights activist. My only purpose of being here is to ensure that the public has equal access to public meetings and that disabled people can make comments at meetings that concern our access to programs and services provided by the city. This task force has made it very clear in a very disturbing way that they are not interested in preserving that access and that they are interested in reinterpreting the law so that this is going to be defined as a passive body, which can have basically do whatever it wants when it concerns public comment or public access. I stated in this complaint that the access to this meeting was not on the website. It sounds like that's part of a passive body's requirement. I understand there was a migration issue. That doesn't change the fact that there was a violation and that the website did not currently reflect where the meeting was being held, what date it was happening. This body is known for canceling meetings frequently and with very short notice and without posting to the website sometimes. That's why there's so many complaints that I've brought up to the Sunshine Task Force about it. I'm not an attorney. I'm just a layperson. Deborah Kaplan here has the support. The city attorney of San Francisco. You all have the support. When I'm speaking to you all, I mean the task force. You have the support of the city attorney's office. You can ask them questions, get all kinds of free legal advice. I cannot. I was not here prepared to cite legal, all sorts of legal stuff from those sections. I'm happy to provide that in my appeals. If there's an appeals process, I'm still waiting to hear back from that. I'm more at that point, I'm just going to call lawyers and start talking about other ways of accessing my rights because those are being taken away very rapidly. It sounds like I don't know how members of the task force here can sleep at night knowing that they're taking away public access from disabled people to public meetings for the Disability Council of all things. But that's what you all are doing, and that will rest on your conscience.
Thank you.
Okay, thank you to both parties. Just briefly to correct the record here. There were statements made that the Mayor's Disability Council was appointed by the mayor. I don't think that is in dispute at all. I would note that Administrative Code 67(3)(c) says passive meeting body shall mean subsection 1, advisory committees created by the initiative of a member of a policy body, the mayor, or a department head. So I believe that the definition that Mr. Carneses provided to us fits squarely with that provision. Moreover, in the last meeting, I made several citations on the classification of this particular body, including by the civil grand jury through their extensive report, Commission Impossible, I believe it was entitled. And that civil grand jury, as well as the city department, city attorney and other agencies over the years, have classified this particular body as a passive meeting body. So I want to be very clear for the record that this is not a change that the task force has made, but reflects past precedent and evaluation made by numerous independent groups here in the city. And with that said, I believe Member Kumar had some comments. I will turn it over to her.
This might be a bit of a long comment for what I usually give, but please bear with me. From whatever I am reading here, I'm getting the impression that the Mayor's Office of Disability is, changing the names of the council, sort of like to insinuate it's a passive body. Let me be clear. The Mayor's Disability Council is a passive meeting body, but Mr. Carneses' case is against the Mayor's Office of Disability. And I did my research before this meeting, and I can tell you very clearly that the Mayor's Office of Disability is an active, body. There have been multiple instances. For example, I'll give you. They have engaged in policy implementation and enforcement, public engagement and advising, response and outreach. They have, there are specific examples of where they have, under the office has the authority to develop and issue policies and procedures, ensuring all city departments comply with the ADA. I don't think a passive body does that. They ODA partners with city planning and SFHSA on the aging and disability affordable housing implementation plan. I don't think a passive body does that as well. And through the Mayor's Disability Council, they have institutionalized infrared assistive learning systems, open captioning and ASL interpretation, and a lot of other things. So, and they also have a current project that started in April 2025, the MOD transition into the HSA department, becoming the Office on Disability and Accessibility, expanding their role within broader social service delivery. So I feel Mr. Carnegie's case is against the Mayor's Office of Disability. So I think just because the MOD is saying that, the MDC is a passive meeting body, I feel Mr. Carnegie's case is still valid, and this they should be held accountable because they are not a passive body. They are very much an active body. The MOD is an active body. That's all I wanted to say.
Thank you, Member Kumar. Any other comments, members? I'm going to respectfully disagree with your assessment. The Mayor's Office on Disability, I believe, is a department or sub-department as much as the planning department is versus the planning commission. And I think there's some confusion. The mayor's office on disability is a department. And so the open meeting rules don't apply. They're city employees. And it even talks about that passive meeting bodies are not, it says right here, passive meeting, these are groups. I mean, it's not the department itself is not a body one way or the other, as much as the clerk's office staff isn't a body. The Board of Supervisors is the body that they support, for instance. But if you go down to the clerk's office, it's not Pat and Angela Calvillo and Elisa Samara are not in and of themselves some type of body. They're just city employees supporting the body. So I believe the Mayor's Office on Disability is the city department that supports the Disability Council. So the Disability Council is the one, is the body. And that can either be a passive meeting body or a policy body. But I don't believe that this office of Mayor's Office on Disability is either. It's a department.
Chair Yankees, then if we just look at the MDC, I still believe it does have, it has an active role, like it advises the mayor on disability issues, and it, the MDC can draft, vote on, and forward resolutions to the mayor. While, the description of passive body means certain things, they are doing a lot of activities that are done by active bodies. I'm sort of thinking that maybe this case can be a precedent for us to, look at what, if we are defining a body as a passive body, they should be meeting all the requirements of a passive body and not engaging in any activities that, insinuate it can be an active body, because it is confusing for people, folks going into these meetings, because, as and I really feel bad for Mr. Carnesi's, because, you don't go into this meeting not knowing what kind of a body it is. You go into that meeting hoping your issues can be resolved and people can hear you. And if nobody is hearing you, then what's the point of us going into these meetings and, raising our voices?
Member LaHood, the member Sugarman.
Yes, I would like to point out, I think the use of some of the terms is a little bit confusing. There are passive meeting bodies, but there are not active meeting bodies. There are passive meeting bodies and there are policy bodies. And I think using the terms passive versus active confuses the matter. Passive meeting bodies have a clear definition in the ordinance. We're not saying that passive meeting bodies aren't active and don't do things. They have very important discussions and they play an advisory role. They have no authority to make decisions. They can advise the mayor, and then the mayor may take up those recommendations, but they have no authority. And I don't know if this came up in the previous meeting or if we should ask our DCA to confirm that this entity that we're discussing is a passive meeting body according to the ordinance. And it's not our call. It just is. Could we ask our... Thank you.
I mean, I would have to look into the, how they were formed, but like you said, the definition is in the ordinance. So that is what a passive meeting body would be.
Yeah, and to member LaHood's point, we did discuss that somewhat in our prior meeting, and I think even as Mr. Carnesi's indicated today, it's a mayor appointed body.
Which meets the definition
of C1. Yeah,
yes.
Exactly. Member Sugarman's next.
I do remember this coming up and asking myself the same question. And if you go to their website and look at their agendas, I noted the difference between theirs and ours, where ours, like this item, for example, has discussion and action, where we take an action. And every agenda that I have seen on theirs, they do have action like adjournment, but every item is a discussion item. They're not taking actions on things. They're simply discussing them. So that's one thing that I wanted to say. The other is simply that from everything that I can see, I do agree that it is a passive body, but I wanted to note, because of what the petitioner has said, which part of it does resonate with me, that this is a disability body. And frankly, I think that the access to potentially making public comment and the access to information on their respective websites and how they're emailing people, I remember that came up as well. It seems kind of like a mess, and I wish we could do more. But if it falls under the realm of a passive body, that's what it is. So that's where we are with it. That's where I am with it.
Thank you, Member Sugarman. Member Pilpa, go ahead.
Clarifying question to Ms. Kaplan. Can you hear Ms.? Okay.
I'm here, yes.
Okay. I just did a quick look at Administrative Code Sections 2A.22. Is that in fact the section that currently created your office and governs your office? Is that the right section reference?
I don't know the numbers off the top of my head.
Okay. Maybe if someone can take a quick look, Administrative Code 2A.22. Am I correct in my continuing belief that the Mayor's Disability Council, the MDC, is not anywhere in city code and is thus was not the subject of an ordinance?
That's correct.
Okay. So to the extent that it exists, it was created by Mayor Brown and continued by others, et cetera. That's
Correct.
accurate?
Yes, that's correct.
Okay. And to the extent that you've now moved from the city administrator's office to HSA, DAAS, whatever you're housed in, I think you indicated last month that you were going to be proposing an ordinance to transfer that jurisdiction. So there may be an amendment in the not too distant future to clarify that. And you may or may not include the Disability Council by name, but if you do not, then it will continue to be a passive meeting body as defined, and your office will continue to exist as an entity under the administrative code. Does that sound about right?
Yes, it does. We're currently actively engaged in discussions through HSA to the Board of Supervisors about the language of those amendments. And right now, the intent is to keep the status of the MDC the same.
The same. Okay.
Yes.
Fair enough. And let me think. Okay.
I mean, just to elaborate a little, I mean, given, the fact that there is a body that is looking at reducing the number of commissions, it's probably not the best time to be proposing a new policy board.
Fair enough. I think I commented last month on this to the extent that the requirements for a passive meeting body are relatively small and minor, and yet the way that you provide notice and conduct the meetings, as has occurred for the last 20 plus 30 years almost, has far exceeded those requirements, and it is more like a policy body, but it is not required to be or mirror those provisions.
That's correct. And, we're very open to any recommendations from members of our community or others in the city about how we can do that better, because that definitely is our intention. As you can see from the agendas, if you have looked at them, we offer several different times for public comments during the meetings. We advertise the meetings on social media as well as the website. And then, as I said, have a mailing list of over 600 people that notices regularly go to.
Okay. So again, above and beyond, and anyone, whether it's Mr. Carneses, myself, anyone else who's listening to this, can communicate with you or your office by email, by phone, 554-6789. It's very easy to remember. I presume that's still the main number. And you're happy to take those suggestions and do what you can with them, but you're certainly open to modifying things and making them better. And
that's absolutely right.
And I appreciate that. Thank you for your time.
Member Kumar?
I do want to say I was going through the agenda of their meeting, and I do feel that they did fail to take public comment even after stating on the agenda that they will. And I just want to say that if my concern is if we let this go, there are several departments that will sort of they are passive bodies and they won't be held accountable for not taking public comments. I honestly feel we should find a violation of 67.15A that every agenda should provide an opportunity for members of the public to address them, because this opportunity was not provided to Mr. Carnesi.
To correct, this is not the public comment case. That was when we heard last meeting. This is the noticing case. So this case doesn't have anything to do with public comment. This is whether or not they posted noticing required. That's a violation on this one. So this is not the public comment one. That was when we voted on last meeting.
And it really does turn on each of our analyses on whether it's a passive meeting body or a policy body. And it's really either one or the other, but not both. And members can come to their own conclusions. We've opined on this a few times.
Member
I'm just going to say quickly, I want to make sure if Member Wolf is here and wants to make comment that we hear from him. But the other thing is, Member Kumar, I hear what you're saying, and maybe there's not an opportunity for us to change the regulations now, but we are looking at the ordinance and making recommendations for amendments. You know, and we can't do everything, but maybe that's an opportunity where, as you're saying, you're looking for more opportunities for the public to participate, and maybe we can have that discussion and see if there are recommendations that we can make that obviously we, again, can't enforce, but that we can be part of fostering that discussion.
Okay. I think we've all kind of weighed in numerous times on this one. Do we have any motions on this item? Or did you have
Member Wolf?
Okay.
I just want to mention one thing, that there is a document on their website that describes what the Disability Council is and what it's supposed to do. And this was, it mentions that it was reorganized by the mayor in October 1998, which was Mayor Lee, I believe.
No.
No?
Member Brown, Willie Brown.
Okay. But it has it's on Mayor Lee's letterhead.
Fair enough.
Okay. But it does specify what it's supposed to do with regards to public meetings, with regards to the Disability Council. Now, whether that is applicable to the Sunshine Ordinance or not is in question here, but it's fairly specific that the meetings are meant to be public and they're to set a certain standard for accessibility with various different assistive technology, removal of physical barriers, sign language interpreters, televised open captioning, telephone bridge for public comment from home. It specifies when they meet, and that there's a schedule that is published on Granicus. So, the question is whether or not they are subject to Sunshine or the Brown Act or whatever open meetings laws there are. I think, there should be, we should at least advise the mayor's office on accessibility and disability now to the Disability Council that they continue to follow what was enshrined to them by the mayor at that time. And it specifies to provide a better vehicle for public input. So it's very clear as to what the purpose of the Disability Council is for. I'll stop.
To Member Wolf, that's all well and good. And I think that they, as we referenced, exceed the requirements that are applicable. And I suspect that document that you're referencing that isn't in our packet was merely memorializing what some of the relevant history was. And they are free to conduct themselves in the way that they see fit and meet or exceed that. But that's, those are their own rules of conduct. We don't enforce the rules of conduct of any particular body or rules of order or procedures, except to the extent that they're required under the Brown Act or the PRA or the Sunshine Ordinance. And so I think our first inquiry here is what type of a body it is. And if we believe that it is a passive meeting body, then I'm not sure that any of the other requirements beyond 67.4 apply. And if they've complied with or exceeded the requirements in 67.4, then I'm persuaded that there's no violation. And I'm happy to move or support that. And if people feel otherwise, they are free and encouraged to vote otherwise.
Mr. Chair, just the last point, I think
Sure, go ahead, Member Wolf.
in the spirit of sunshine and in the spirit of bodies like this that are being specified to provide specific public input, and with all that we've been dealing with around public input and remote public input and all of that, I think it's worthwhile for us and within our, kind of scope for the work that we do, that there's no one else that would do it if we would at least inform and advise the department to follow the rules that were laid upon it is enough. Otherwise, I feel like we're shirking our responsibility in spirit of what this law is, how powerful it is, and what it represents internationally. I think it's important to maintain that for our city and our people.
I mean, largely, Member Wolf, I agree with your philosophy that we should be promoting sunshine. I mean, obviously, that's why we're all here. And we have the representative from the office here, and I think has taken into consideration a lot of the feedback that we've discussed both at this meeting and the prior meeting. And as I'm hearing this, and I think that's a good document that you pointed out, Member Wolf, because it makes me believe that perhaps if Mr. Carnazes believes that the Disability Council is not meeting the expectations of the mayor, then perhaps it's the mayor or some other executive of the mayor's staff who would be the appropriate party to enforce or to otherwise help put the Disability Council on the right track to meet the mayor's expectations, assuming the current mayor has the same expectations as the prior mayor who may or may not have authored this document, depending on the year and letterhead that it's on. So I think for our purposes, since this is a complaint that was brought and is alleging a violation of the Sunshine Ordinance, I think that I'm largely in agreement with Member Pilpel that we need to look and decide, is it a passive meeting body or not, and then find if it is a passive meeting body, what regulations do they have to follow? If it's a policy body, what regulations do they have to follow? And in this case, I think most of us have determined, at least in our own minds, that this falls under the definition of a passive meeting body. That's not to say that Mr. Carnazes' goals aren't noble. I just think he may be using the wrong city resource to achieve his goals. I don't think we can make the difference that he wants to see happen, as noble of a goal as that is, because I just don't believe that this is under our purview. I think that perhaps working with those people in the mayor's office who would actually be able to enforce that directive may lead to more change. That's kind of where I'm at. Member Sugarman.
Just reading section 67.3 a little bit more. I mean, it does still appear to me to be a passive meeting body, but there are several definitions for policy body. And I think that it would, I mean, in those definitions, it isn't really, it could still be an advisory board as a policy body. It could literally just be advising and not doing anything. So I guess my only lingering question is, I mean, who has like if this has come up, I apologize, but how was this body formed? I mean, we discussed it being formed by the mayor.
Right.
But like, was there initiative? Was there a document? Was there something that was, proposed?
Yes, we ran through those definitions, Member Sugarman, at the last meeting, the one I think you're referencing in D about the policy body, right? So we went through, so it was not made by the Board of Supervisors. It was not made by a board or commission enumerated in the charter. It was not a board, commission, committee, or other body created by ordinance or resolution of the board. So the board was not involved in the creation of this in any way.
But they funded it, supposedly.
A lot of things get funded through the city budget.
Okay, go on, please.
An advisory board, commission, committee, or body created by the initiative of a policy body. So this was not a policy body creating like a sub-policy body. And any standing committee of a policy body, irrespective of its composition. So we went through, there was no controlling resolution ever passed by the board, ever passed by a policy body. Both the petitioner and the respondent were in agreement that it was the mayor who formed it unilaterally as an advisory committee, which falls squarely under the C1 definition for passive meeting body.
Okay, thank you.
Like I said, that was
does help me.
also documented, I read last time, by the civil grand jury. They did a big chart. They went and found every controlling resolution and determined that as well.
Thank you.
I'll just say one more thing, and again, I'm happy to make the motion unless someone else wants to. If any member of the Board of Supervisors wants to add this to the code, that would make it a policy body. That has not happened for the entire life of the MDC. And as I think I opined last month, one of the reasons for that, in my view, is that at the time, nobody else was doing phone-ins to meetings. They were the first body to ever do that in this city. It was pretty amazing. And, I can remember on a third Friday afternoon at 1 or 2 o'clock, whenever their regular thing was, you knew that you could watch it on TV, you could call in real time, and that was like amazing. And that was like, nearly 30 years ago. And I believe the view was that making it a policy body would limit it to the requirements that we go through as a policy body with notice and an agenda, public comment, et cetera, and wouldn't give them as much flexibility to address the range of disabilities that they deal with, whether it's physical, mental, other, that provide challenges and that they are uniquely able to address with phone-in, with closed captioning, with open captioning, with a variety of different modifications and adjustments that aren't always easily addressed by a policy body or a Brown Act body. So I think they're actually doing better than required, but that's just me.
Okay, I think we've been at this one now for quite some time, and let's see if we can get a motion on the table for this.
On the specific petition or complaint before us, I would move to find no violation.
Okay, so there's a motion by member Pilpel to find no violation. Is there a second to that motion?
And to clarify, that's no violation of the Sunshine Ordinance.
Right, no violation of the Sunshine Ordinance.
If there's a second.
Okay, I will second that. Let's move to public comment on that motion.
Taking public comment on the motion. For item 10, if you wish to make public comment and you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one in the queue.
Okay, I will go ahead and close public comment and let's move to a vote on that motion.
Can I ask a question?
Sure, go ahead.
About, as we discussed earlier with our orders of determination, sometimes there's additional wording that conveys our thoughts that don't actually have so much to do with the order itself. Would we want to say anything that we encourage the, we encourage, well, I guess it's not even the council, but the department supporting the council to improve its presentation of meeting information on its website. And given what was sent to us, we understand that some of this has to do with technical migration, or do we not want to get into that because it has to do with the migration of the website, which is, I don't know. Is that helpful? Is that useful? Does that?
I think we certainly could if that's something you wanted to suggest to the maker of the motion. I don't think it's inappropriate that we do that.
Yeah, I don't know. Does the maker of the motion think that would be useful or helpful or address some of the petitioner's concerns without identifying this as, we're acknowledging, we're saying there's no violation, and we encourage the department to work toward better presentation of agendas on its website as it is going through this website migration process.
Or agenda. I'm open to that. Do you want me to recraft language?
What do
Would that
others
help?
think? I don't know. Is there support for this?
I certainly don't think it's a bad idea to encourage that. I think it puts us on record to support the cause that Mr. Carnazes is seeking without saying that it actually is a violation of the law. I think that kind of helps cover both bases. So I would be supportive of that. Member Kumar, did you have your hand up?
This is just a comment. I just want to say, even if you're migrating websites, you can still, get a piece of pen and paper and write out the agenda. There are ways you can use cloud tools or something like that. You don't have to, or, Word. There's so many ways. If they wanted to do it, they could have done it. That's all I wanted to say. But yeah, rest I'll leave to the task force.
So Member Pilpel, did you want to incorporate language to that?
Yeah, and I'm sorry if the motion came off as, too terse. I was not intending it to sound that way, and I'm now reflecting that maybe. If we could add a sentence that the task force encourages the Office of Disability and Accessibility to clarify in its meeting notices and agendas, opportunities for public comment, and ways to engage with the Disability Council and with the office. Just as
And
much
making
as
sure the
possible.
notices are are posted where people can easily find them.
Sure. We may need to get this read back, but yeah. And I think I got a sense earlier from Ms. Kaplan that they're very open to this. So I think that's fine. I have no problem.
So the revised motion reads, motion by Member Pilpel, seconded by Chair Yankee, to find no violation of the Sunshine Ordinance, and that the task force encourages the Office of Disability and Accessibility to clarify its meeting notices and agendas and opportunities for public comment and ways to engage with the Disability Council and office, and making sure that the notices are posted where they are accessible or can be found, or
Where they are easy to find and accessible.
that the notices are posted where they are easy to find and accessible.
Does that work? It's probably too many words, but
It'll work.
Yeah.
It was
Yeah,
many
we've been on this one for a while. I think it conveys everything. And I'm fine with that as a seconder. Okay.
Thank you for improving the motion.
Okay.
Yeah.
So let's go ahead and move to a vote on that.
Public comment on the,
Sure, we'll just, because we did change it slightly, go ahead. We'll reopen to vote.
anyone wishing to make public comment on the changes to the motion, please approach the podium if you're in the room, or if you're online, please raise your hand in the app or press *3. We have no one in the queue.
Okay, public comment is closed and we will move to a vote on that.
And if I might, if this passes, perhaps this might address any other complaints that Mr. Carnazes has, if there are others that we haven't heard yet that are similar, but
Yes,
whatever. one
I'll
at a
get to
time.
that in a sec. So let's vote
Sure.
first.
I'm taking the vote on item 10. Member Pilpel.
Aye.
Member Pilpel, aye. Chair Yankee.
Aye.
Chair Yankee, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
No.
Member Kumar, no. Member Anderson, absent. Member Highland.
Aye.
Member Highland, aye. Member Wolf.
Unfortunately, this time I'm gonna have to vote in favor. Though I don't necessarily like it, but I think it's kind of ultimately the response and the correct interpretation
That's an aye.
at this point. Yes, it's an aye.
Member Wolf, aye. Vice Chair Stein, absent. 2 absent, 1 no, 7 ayes.
Okay, that motion passes. And then to Mr. Carnazes, you had made some comments earlier about your remaining cases. We've held them open for years now. I think they're at least 2, if not longer years old. We're going to continue to schedule them. If for some reason, though, you want to withdraw them, you're certainly free to do so and work with our administrator on that, and we can have them closed if that's what you prefer. But we're not going to have them remain open and pending any longer. So the choices are either to have them continue to be scheduled or to close them. Okay, thank you to the parties. Administrator, I know you've been sitting for quite some time. Did you need a short break?
I would appreciate a break.
Okay, so why don't we plan to come back? It's about 6:41 now. Why don't we come back about 6:50?
And what are we hearing next?
We will be hearing item 14 next.
Great, thank you.
Microphones are off.
How long is this break for? I did not hear that.
You did not hear that because the microphones are off. 10 minutes.
10 minutes, thank you.
Guys.
Yeah. We're only this for luck.
Microphones are on at 6:51 PM. A break was taken, starting at 6:41 PM.
Okay, so we're back at 6:52 and we have,
No quorum.
we lost member Highland.
Do we have member Wolf online?
I do not see him there. Oh, here's member Highland. Okay, so it's back at 6:52. Oh, I see member Wolf. So we're back at 6:52 with all members except for member Kumar. We do have a quorum, so we can continue along.
I'm here by audio.
So noted. Thank you, Member Wolf. Item 14.
Yeah, go ahead and read item 14.
Do we need?
After I read it, yeah.
Item number 14, file number 25034, complaint filed by Joe Fitzgerald Rodriguez against the office of the mayor for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. On June 17, 2025, the Complaint Committee found that the task force has jurisdiction, that the requested records are public, and referred the matter to the full task force to consider a violation of Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. Chair Yankee, we received word from the respondent on the 26th that he would not be present at this evening's meeting.
We did. I think I see a respondent in the chat.
Oh, it's in,
I don't believe this was that. I didn't see that.
I'm sorry, I can't hear you.
I think there is a respondent available in the online meeting. I believe there would be a respondent.
I'm sorry, I was referring to item 15.
Yeah.
I was
that's what
correct
thought.
that. And we do have petitioner present in the room. Mr. Darmali, I am promoting you to panelist.
And you can come up to the podium.
Ew.
Hello. Okay. I understand that there's a few disclosures members want to make, so let me turn it over to any member who wants to make a disclosure.
Oh, yes. I would like to make a disclosure. I am on the SPJ NorCal board with the petitioner, but there is no financial relationship between us. I don't think he does not employ me. I do not employ him. We're both volunteers there. Also, he is not representing that organization in this complaint, so I don't see a need to recuse myself, but I wanted to bring this up to the task force.
Thank you, Member LaHood. Anyone else? Member Popa?
I have known Joe for a number of years. I would not deem us close friends despite comments that I've made in the past. I would consider him more than an acquaintance. And nevertheless, I am open to argument and persuasion on the facts. I believe that I would be impartial, and I believe I can hear this matter without bias.
Okay, Member Schmidt?
Just to be on the safe side, I am appointed by the SPJ.
Oh, right. I am also appointed by SPJ NorCal.
But I don't see any need for any kind of recusal. I can judge this fairly.
And I have something to add. And
Okay,
I'm
go
an acquaintance. I've been to events where Joe has been there. We've said hello. That's about the long and short of it.
And perhaps when Member Kumar gets back, she might have something to say as well.
Okay. Okay, so let's get a summary of this case. It looks like it went to the complaint committee on June 17th, so I will turn it over to Member Schmidt for that.
Yeah, this one is pretty straightforward. The initial claim, the primary claim, is that there's an IDR violation, and the petitioner makes a case that the request was the kind of simple request where an IDR needs to be complied with. The backup claim, I'll just say, is a 6721 claim. I think that people should be looking at the extension requests, whatever time passes to respond to the requests, whether people think that this is IDR material. And I just want to make sure that all the documents have been produced. Otherwise, we might need to order production. Other members of the committee, anything to add?
Yes, simply that in discussion, I recommended forwarding it to the full task force because while it does seem like a simple request, the lower half of the request did seem like it potentially posed a burden for the office.
Okay, so we'll go ahead and start with 5 minutes for Mr. Rodriguez and Mr. Peterson, if you could let him know when he can begin.
Are you ready?
Yeah.
Your time begins now.
Thank you so much. Task force members, thank you so much for being here tonight and for your volunteer time and for hearing out both sides of this. On April 17th, the mayor's budget office sent an email to department heads requesting a list of their department's grant implemented programming and any performance information provided by the grantees, and with essentially analysis of what those departments should cut to make further cuts in Mayor Daniel Lurie's budget. As a journalist, 12 plus year journalist now with the San Francisco Standard, it was my interest to get these budget recommendations for news coverage. And seeing as how this was a simple email that Ms. Kittler, Sophia Kittler from the mayor's budget office sent to all these departments simultaneously, to my mind, I said, well, gosh, I would just like all the replies. And that seemed to me a pretty simple immediate disclosure request. It's easily identifiable. You can find it simply by looking for all the replies to that email. And, in the last meeting we had on this with the committee, with the task force committee, the mayor's office said something about not being able to identify a respondent. And I'm like, I'm sorry, but Sophia Kittler is the person who I requested the emails from. Pretty easy to identify that person. She's named in the request. And as far as the responses go, you just look for replies. It seemed to me pretty straightforward. Member Sugarman brought up in the committee, I think quite logically, and I appreciate your journalistic experience and kind of pointing this out, that the bottom half of my email talks about some kind of stringent ideas, right? Be certain to perform an IT or server search and recycle bin and trash and delete items. There are some kind of catch-alls that, over the years, different journalists and different people who conduct sunshine requests have added and I think are good policy to include in just about any request. However, I think the most important thing in this bottom half is the section that says you must provide rolling responses. 6725D, as I'm sure all of you are aware, I'm preaching to the choir there. And I think, Member Sugarman's point is, well taken. There's a lot of really scary stuff in this legalese, absolutely. But the rolling responses to me trumps all of that. And if there is something simple like a reply that you can look for without having to deal with all the gobbledygook I had up above it, well, then that should come first. The gobbledygook can come second. I know it's scary looking at legalese, but this is the mayor's office. This is not, a small commission with a small staff. This is the most robustly staffed and most robustly prepared legally department in all of the city and county of San Francisco. So they know how to look at the rolling basis requirement and say, hey, Joe has asked for some replies to some emails. Maybe there's some stuff we got to redact with city attorney. Totally. And they ultimately did. I understand that. I wouldn't have asked for those. I wouldn't have thought that those had to be given to me right away. There's definitely some stuff they had to redact. And I hope I'm not shooting myself in the foot by mentioning it, but there are emails that were more straightforward, that really had very cursory information about the budget that would have been helpful to me as a journalist, helpful to the public to know in a timely fashion, and I think easily fell under an IDR status. Last but not least, I just, without citing code, just as a journalist, as a member of the public, I have seen agencies run roughshod over this idea of providing rolling basis documents. You all have probably seen it. I really is unfortunate to see any agency, especially the mayor's office, take any license to deny rolling basis documents. And I would really hope my biggest interest in this, all the documents have been given to me. Let's be clear. I have all the documents. I have them all now. I have done news off of those documents. They were very useful for that.
30 seconds.
Thank you. But my interest is making sure that in the future, rolling basis is honored and that the mayor's office holds to it. Thank you very much, everyone. I really appreciate what you do.
Okay, thank you. Stay here.
Thank you.
You got Member Kumar at 7:01. Okay. So
Was that
let's go
7:01?
to the response.
Picked up 701.
At 7:01.
Do you want to ask Member Kumar if she has any?
Did you have any disclosures related to this case before us? Some members were speaking of their association with SBJ.
Speaking to Mike.
I would like to disclose that I'm on the board of SPJ NorCal.
Okay. But you can still hear this case and be impartial.
Yeah, I mean, I think I can be impartial because this is in Joe's capacity as an individual journalist, and it's and I don't work actively with this department, or I have not raised a sunshine request in a while. So I think I'll be objective in this matter. Yeah.
Okay, thank you. All right, I think we can get to the respondent now.
Mr. Darmali, are you ready for your 5 minutes?
Yes, thank you.
Your time begins now.
Great. Good evening, members of the task force and the committee staff as well. Firstly, thank you all for the time you put into this work. I want to be very clear that this complaint is about an immediate disclosure request. And what I would like us to focus on is the IDR and the complaint concerning that, and not other facets that, might have been issues of previous administrations. So with that in mind, I'd really like to read a portion of the complaint on why we were not able to treat this request as an immediate disclosure request. So part of the request from Mr. Fitzgerald says, please provide exact copies of all records, such as your agencies, its employees, and where contracts give your agency's interest in or rights of access to the records, its contractors as well. Be certain to perform an IT search, server search, or recycling bin trash, deleted item search, an archive backup search, produce electronic records in their original electronic format, produce all electronic metadata associated with each responsive record, produce all attachments for all responsive records, search all government and personal property, preserve all original responsive records until the completion of all possible appeals or complaints for emails preserved at least 2 from CC, BCC, email addresses, dates, times, body content, formatting, hyperlinks, URLs, attachments, and other email headers for text or chat messages of any other form, preserve at least the sender, all recipients, dates, times, text, content, images, audio, videos, attachments, formatting, hyperlinks, and URLs. The reason why I bring that up is because the ask of this request was not routine or a simple task. And our office wanted to be sure we were doing our full due diligence in honoring this request and following the Sunshine Ordinance, as this was our office's first budget season. And we wanted to be mindful of exemptions that fall within the ordinance and making sure that the documents we were producing were not causing more harm than they would be good. The request is now closed and the documents have been produced as that has been established, and there is no issue on that front. But the part of this being considered an immediate disclosure request is quite a burden to an office. And we can say with hindsight, sure, maybe there was only one individual that this information was held within our office, but that's something that really only with hindsight we're able to say. But when our office first received this request, it named the individual, but it was asking for replies and many other parts. And the mayor's budget office, even though it has one director, has many analysts in it that work beneath a director. And so as you could imagine, asking one department, give me everything that this one director has sent out, can lead down many different paths. So we wanted to make sure we did our due diligence rather than only producing one aspect of the request. As you can know, as you probably imagine, like as being inside the office, you see a different aspect of it. And so we wanted to make sure that during our first budget in this administration, we were honoring the Sunshine Ordinance and completing the requests to the best of our ability. And with that, the request is now closed and the documents are produced. And I'll leave that there for now. Thank you so much.
Thank you.
Okay. Members, do we have any questions on this file? Go ahead, Member Papa.
Okay. Let me start with Joe. So I think I understood from you that all the documents that you requested, you've received, and it's not an issue. So there's no further disclosure that's needed.
No, there's not.
Okay. But I did think that I heard concern about the amount of time that it took, rolling basis. Did you express concerns about redaction? I had some concerns about redaction, but I'm not sure if you.
Oh, I mean, I certainly have concerns about redaction. I just didn't want to muddy up my all of our discussions about everything else with that. I was considering a separate complaint, to be honest. However, that aside, they did at first close my request without any of the attachments. But this, I think, is, that's important for one good reason. They're not paying attention to what is being said in this paragraph. They're bringing it up now as like a reason why it's like, oh gosh, we couldn't have immediately disclosed it because look at how technical and legalese this is. But if they were paying attention to it so closely, then they would have seen the part that said, give me the attachments. They gave me 0 attachments and they told me that my request was closed. It's very clear to me they didn't read any of this bottom portion. They looked at it, thought it was a bunch of legalese gobbledygook, ignored it, and moved on. Now that they're being called on it, they are, I can't ascribe to them necessarily the intention, but that is my hunch. And the hunch is borne out by the fact that they didn't provide those attachments, which is a huge oversight to not provide attachments.
Okay, I'll come back to that. Is it further your contention that the amount of time from when you first submitted the request, which I think was April 28th, to June, was it June when they finally?
Yes, they finally gave me everything on June 5th, which is well past when it would have mattered for news purposes. And I think that was, not exactly, I mean, I can't say what's in the heart of the mayor's office, but as someone who's been a reporter for a long time, and as I'm sure all of you in your different capacities with your experience with government know, it's not exactly a giant leap of logic to go, oh gosh, they got me all the attachments after the budget process was done and after reporting on it would have been the most important to do. Gosh, gee willikers.
Okay, I'm not addressing that right this second. If I go to,
Fair.
I'm sorry, not all of these pages are numbered. There was an email from the mayor's office to you dated June 5th with a set of attachments, starting with copy of 2 and ending with TTX.
Correct.
Were those essentially the subject attachments that you were looking for, or was this one tranche of several? I'm not clear.
I'm pretty sure that was the majority of the ones I was looking for.
Okay.
You forgive me. I've been on parental leave for a little while, so my brain is a little Swiss cheese.
What
baby has to eat every 3 hours.
Okay. What I'm getting at is, is it your view that in response to your April 28th request, that they could have said, here's what we have now. If we find anything else, we will provide it on a rolling basis.
Yeah.
So that you, et cetera, and that should not have taken 5 or 6 weeks.
That is my contention, is that there are parts of this that they, later had to redact, had to run through a city attorney. I get that. But there are parts of this that are far more direct, far more simple. Even a layman could look through it and say that there's not really anything that should be easily flagged. And they could have provided that on a rolling basis.
And you were not seeking people's personal cell numbers or official information under Evidence Code 1040 or anything like that.
No.
You were actually looking for the contracts that were at issue and subject to budget cuts.
Correct.
Okay. And we're not going to argue about the budget, good, bad, or otherwise tonight. We're just talking about records. Okay.
No.
And finally, in response to your April 28th request, did the mayor's office come back to you and say, hey, we're not sure exactly what you're looking for, or there's too much? Can you narrow? Can you focus? Can you prioritize? Was there any of that back and forth that sometimes happens?
No, they didn't. And that is a point I wanted to make to you members. Oh, yes?
It's okay. I'm just putting myself in the queue for when.
Oh, okay. And that is a point I wanted to make to you members, is that this is not a department that is unfamiliar with me. So this is, if you forgive me, the mayor's spokesperson. These are the number of phone calls I have with the mayor's spokesperson. It's at least like 4 a day, usually on any given weekday. There is like ample, I mean, sometimes a few days without talking, but mostly 2 to 4 phone calls a day with the mayor's spokesperson. There is ample opportunity for them to go, hey, this thing was a little too burdensome for an IDR. Can you narrow it down and we'll do it? Plenty of opportunity. Okay. And I will say, there was a separate IDR in a similar case, but far smaller, where the district attorney's office produced the IDR on a rolling basis immediately, giving me a letter from Brooke Jenkins to the mayor's budget office in a similar request. In fact, this letter was encompassed in this request as well. And the mayor's budget office also pushed me off that request and said they needed more time. I'm sorry, but why can the DA's office produce that on a rolling basis immediately, but the mayor's office cannot? That is strange.
It's the same information, and it's as equally helpful, complicated, embarrassing to either side if it's a budget cut request, et cetera.
Correct.
So the burdens fall equally.
Correct.
Okay. Thank you. You've answered my questions.
Thank you.
Can I go to Mr. Darmley, or do you want to go to membership?
Why don't you finish up and then we'll go to Mr. Member Sugarman.
Okay.
Oh, and for the record, Member Highland had to leave at 7:13 p.m.
Got it. Okay. So to Mr. Darmley, and I don't believe we've met yet, but welcome.
Thank you.
The first thing, and I've asked this of many others before, for example, on page 8, your responses at the end, best, Office of the Mayor, San Francisco Sunshine Requests. I have been very consistent in asking departments to indicate who is sending communications so that they're not just from, mayor's office or sunshine requests at SF Mayor, that you actually attach a name and, where applicable, title and contact information so that it's clear. And if you could do that going forward, I, for one, would appreciate that. Going back on some of my questions with Joe, there was no back and forth to clarify narrow or focus in response to his initial request?
No, not that I'm aware of. When this request originally came in, it was a different member of the staff that was overseeing it, and there's been some transition in who is overseeing our sunshine request. So that could be part of where there could be some differences in approach. And this is new administration, so we're working out our systems and ironing out all the wrinkles. So that is part of this process as well for us.
Okay, and this may well be a learning opportunity here. So far, I don't sense that there was intent to muck this up, there may have been delays and all of that, but maybe we're taking a moment here to figure out how going forward is a better way. So in that spirit, I would suggest not just putting a name to it, but where you or whoever is covering for you gets a request that appears to be overly broad or complicated or an IDR or labeled as an IDR that you don't consider an IDR, I'd encourage you to follow up with the requester and say, here's what we see, here's how we view it, if necessary, what are you really trying to get at here? How can we help you get at it? If it's, 400 boxes and 5,000 pages of stuff, what's most important? How can we get through this? How can we work together to get you what you need and so that we can all move on? Something like that.
Absolutely. And that's definitely what our offices have been doing more of, because we get very large requests, but we really try to work with the requester and say, like, you're asking for all documents, but really, is there something specific we can help you pinpoint faster so we can get you the documents turned around on a shorter timetable, and being mindful of deadlines? That's definitely something that we've started to incorporate. And I'm sure many of Mr. Fitzgerald's colleagues can attest to that as well. We're being very cognizant of helping requesters through the process and making sure they're understanding what we understand and vice versa.
Okay. And just finally, if Joe had said something more vague in general, like, I understand the mayor's office is looking for cuts from departments, what can you tell me about that? You might have required some more effort to focus on that. Because the request said on April 17th, Sophia Kittler sent an email to department heads asking for the following, I would like all of those communications back in response. It seems pretty clear to, anyone in the loop on this, what he was looking for, that it was some kind of a supplemental cuts plan or the impact on grants, et cetera, et cetera. It doesn't seem like it requires that much deciphering. Did you see it differently, or again, did you just sort of inherit this from others?
This request was started by another member of the team.
Got it.
I'll say that I think, like, if we're thinking about the example of the district attorney letter, I think that's if that's what has brought us to this point. I think for one department, it's very different because their interaction is typically with. Actually, I won't even speak to that because I'm not sure how the internal working of the budget team.
Results may vary.
Yeah, the results may vary depending on so many different parts of that process. But when thinking like the district attorney and the mayor's budget office, that's a very linear relation. Whereas the mayor's budget office and all city departments, that takes a lot of review of documents and is like a lot more of a burden than one department with interaction with the mayor's budget office rather than the mayor's budget office with all departments.
Understood. And just finally, and I don't know how much we're going to focus on redaction from the documents that I reviewed, it seemed to me like there was some redaction that's pretty acceptable.
I don't think we're getting a redaction on this case. So let's.
Okay. Again, I don't want to focus on this, but I'm just pointing out there was some redaction that I didn't have any particular issue with. There were others where there were big blocks of thing and it wasn't clear what was being redacted and why. And we could go into more detail about position numbers and justification and names and such that I'm not sure there is a great basis for redaction. But if that's not what we're focusing on tonight, I'll put that aside for now.
Let me get over to Member Sugarman and then Member Kumar in the queue.
Right there. So this is for Mr. Fitzgerald Rodriguez. I was just noting that the request was made in the afternoon. Basically, this all kind of happened in the span of 4 hours or so. So like you made the request, they responded saying that it was too complex.
Mhm.
And then you, it looked like maybe in a span of 15 minutes filed a complaint with us, correct?
Yep.
So, I guess my first question is, what happened in the ensuing weeks?
What happened in the ensuing weeks is eventually, let's see, what are the dates? In May, I got some of those emails. May 19th, they would notify me that they needed until June 2nd for additional requests. So it was just, there was no retaliation or something. They got me the emails. They said it was closed. They didn't get me the attachments. I told them they erred and then to get me the attachments. And that all happened after the budget process was that budget process what we were writing about was complete.
Right. And to your point that there is no outstanding, requests made. And I do understand the point about it being an IDR. I do understand the importance of it being an IDR based on deadlines and also on scoops, on things that you want to make sure you're having this information first. However, it does seem like I asked this question before, but it does seem like both from what I've heard from you and from the mayor's office tonight, it's kind of on principle. So far on your end of it, it's like, well, you want to hold them accountable and make sure that this happens more quickly in the future. And for the mayor's office, it sounds sort of like they don't want to set a precedent that complex requests will come in and then they have to answer them within an IDR turnaround. And so I'll ask this again. It's not necessarily relevant to our decision, but my question that I asked the complaint committee is, what is your relationship with the mayor's office?
It's actually pretty good. I have to say, I think the mayor's office generally, more so than past mayor's offices, takes things on principle, takes things on the matter at hand. And that's what actually made me feel safe to bring this complaint in the first place. I have been someone who is appointed, I've been in part of a body appointing to this body for, a decade. I've, championed this body and helped put out materials on this body. But I have not personally used this body. And I'll tell you why. It's because it can be seen, as you are flagging, as you were wisely flagging, an adversarial action sometimes when you're dealing with government. And I always felt that way under previous mayors, that if I had brought a complaint here, that it would be seen as an adversarial action and lead to me being cut off. But I don't think it is in this one. I think, like you're saying, we're talking about different precedents. They have one view, I have another view. We're taking it logically over the matter of things. And I think that, whichever way it goes, our relationship will continue to be a productive one for the people of San Francisco.
One last question. Would you say that the part that you put in the bottom of your email with all the requirements for what you were looking for, is that kind of boilerplate for you? Is that something?
It absolutely is. And it is additive over time. Pieces of it are taken from other people's sunshines that I've seen and sunshined and said, wow, that's pretty good. And yoinked. Some of it is from a very prodigious person who came before you quite often, Anonymous. You might recognize. But some of it is written by someone who was a Chronicle journalist and then became a PIO. Some of it's from a standard journalist. It's all over the place. So, yeah, it is boilerplate. However, what I would point out to is that rolling response. So if the mayor's office is worried about complex requests becoming routine and then being held to IDR for it, I would say the difference between a traditional complex request and this one is the rolling response. If they really did think that this was complex, they could have said, Joe, we're going to do that complex stuff in a few weeks, but we'll give you the simple stuff now. And that is what I think they passed it over because they do get a lot of boilerplate. And I understand that. People in workplaces do that. It's fine. But yeah, I think that rolling response is kind of the key. And can I make a quick correction to something someone said? Is that all right? The mayor's office was talking about me citing the DA letter that was given very quickly, but this was not given an IDR because of the broadness of this request. I'm not talking about this request. I'm talking about a different request, right? Requested one single email between the DA's office and the mayor's office. One email. The DA's office produced it. One email exchange. DA's office produced it in a rolling basis, and the mayor's office did not. It was a separate request. It was before this, and it is part of the reason why, Member Sugarman, as you point out, why did I file this in 15 minutes? Because of my experience with that DA's letter when I did not get, a good kind of back and forth on that from the mayor's office.
Thank you.
Thank you.
Great. Let me go.
Joe, Mr. Rodriguez, I have a question for you. So I'm sorry you missed the deadline for the story and you did not get your documents. But in case you do see a potential for another story developing, what would be an ideal timeline by which you would want to get these documents from the office?
The time frame that was most important to this was during the time frame of Lurie formulating his budget. He issued his budget just before June 1st. June 1st, if I think, fell on a Sunday, so he put it out on that Friday beforehand. That I was trying to get stories out beforehand to kind of say, hey, here are the things that the mayor's thinking about as he's forming his budget. That's helpful for the public because the public can then go, Mayor Lurie, we saw on the SF standard that you're considering doing X, Y, and Z things. Well, we would like you not to do them. And that could influence his budget process. But because these documents, some of the most important ones came afterwards, it is almost useless.
So basically not getting those documents on time did affect their reporting, and did they know the urgency of the request? Like, did they know how urgent it was for your story? Like, did you share a timeline with them?
I mean, as I showed this body just a few moments ago, I'm in near constant contact with the mayor's office every single day, or almost every single day. So yeah, they very much knew, okay. Or I told them at least.
So I guess it's safe to say that not getting the documents and getting them now basically is a moot point. There's no point of getting the documents now, right?
Yes.
Okay. I have a question for the office. So when you mentioned that, you had some staffing changes and somebody else was handling the request that led to the delay. At any point, did you notify Mr. Rodriguez?
Not that I am aware of, but as Mr. Rodriguez has said, he's in constant contact with our office, and I don't know what is discussed on those calls. That is not part of the work which talks with our spokesperson and with our sunshine requests are very different workflows. So I'm not aware of what are discussed on those calls.
But I do want to point out that because the staffing change happened, your department was aware of the fact that this was an important story for the journalist, right? Like not giving the documents to the journalist on time would hamper their reporting. Was your department aware of this?
Me individually, I was not made aware of that fact, but I can't speak for what everyone in the office has been told or understood.
All right.
The emails that you see have been shared is the extent of my communication with Mr. Fitzgerald on this issue.
So I want to understand in scenarios where, a journalist has an urgent item to report and, we journalists have to meet deadlines. What typically happens? What procedure do you follow to notify the journalist that this document you're asking for is taking a lot of time, or we don't have, what is the typical process that I can visualize? Say like I submit a request today and, I need it 2 weeks from now and you cannot meet the deadline. Like, how would you sort of notify me? I just want you to walk me through the process.
So could you say that again, please?
Sure. I'm saying that, say I submit a request to your office and I have a deadline 2 weeks from now. I say, I have to file the story in 2 weeks and I urgently need these documents, but you are having your own, something is happening in the department, things are moving around. What would be the typical process of notifying me that you won't be able to meet the request?
Well, first I'll say it is not a common practice of requesters, from what I have seen thus far, to say that they are working against a deadline. That is nothing that has come across in requests that I have seen. So I'll just say that to begin with. But when we do receive a request, we reply and confirm receipt and tell them we thank you for your request. And this is when the request is clear to us about what needs to be collected, and there is not a need to try to speak to the requester about what they are looking for to try to help them pinpoint, because sometimes some requests are not very exact, but they're looking for all communication from one person during all sorts of topics. So bearing that the request does not need to be fine-tuned, we confirm receipt and let the requester know we'll be in touch. Then if the 10-day deadline is approaching and it is becoming apparent that an extension is needed, you typically, because of the need to consult with another department, then we follow up and inform the requester. But in terms of thinking about this situation in front of us with Mr. Fitzgerald, we informed about the need to extend based on the need to consult with another city department. And then it became clear that once we thought the request was closed, it wasn't. We did what we could as quick as we could to collect the needed further documents and produce those as well, so we could close the request and be respectful of like the requester as well.
Okay, thank you.
I have Member Schmidt, then Member Hood, then we'll come back to you.
Yeah. Yes, to the petitioner, I'm looking at the rolling basis language in the in the ordinance. I'm gonna quote from one sentence of 6725D and ask the question. Part of the claim here is that what's called the incremental or rolling basis production was not done correctly.
Yes.
As part of that claim, would you say that in the course of all the production here, that the respondent withheld records that are responsive until all potentially responsive documents have been reviewed and collected? And I'm reading right out of the ordinance here. I'm just wondering if what you saw included that records were not given to you but held until.
Yeah, that's right. So the first communication with me was a few hours after my request, when they said, well, this is not an IDR, this is not simple, routine, or otherwise readily answerable. And then the next reply is on May 8th, saying, thank you for your request. After a reasonable and diligent search, please find responsive records attached. And that is when they have all the emails without the attachments. Now, I guess technically you could say, because they forgot the attachments, it was a rolling basis, but I don't think it was a purposeful rolling basis. To their end, to what they were seeing, they waited until they had every email dialed in, and then they provided all the emails in one batch.
Okay, that's all I have. Thank you.
Okay, Member Hood.
Yes, hi. I have a couple of questions for the petitioner. I'm having trouble navigating what was submitted to us. I see the 3 additional attachments, but do we actually have the emails that were sent to you minus the attachments?
Yeah.
Where am I seeing?
The emails. Oh, Killer's emails. Oh, good question.
Not Kittler's, the ones sent to Kittler.
Yeah.
Without
Oh, I
the
get you. I'm looking.
I see some messages in the attachments, but I don't see. I guess maybe my more important question is, how many different entities sent responses to the city? Do you know how many
more than 20.
More than 20.
Yeah.
But less than 30?
There's roughly 55 city departments, depending on how you cut it or how you slice it. It was definitely not all of them. It was more than 20, might have reached as much as 30.
And did they send you only responses that have been submitted as of the date you made your request? Or did they subsequently send you ones that might have come in after?
Oh, they didn't send ones that came after.
Okay, so they only sent, so we're talking essentially the original email was sent out and roughly 7-8 business days later, you made your request.
Yeah, I gave it time for them to send in a bunch of replies and then go back and forth, kind of figuring, it'll take some time to go back and forth between the mayor's office and the mayor's budget office and the departments. So after that kind of mental estimate of how many, replies they would have given each other, then I sent that request for that definite period of replies to that singular email, which that singular email, might I also add, was one that they had already produced to me previously. So they knew what the originating email was.
Okay.
Triggering all this.
Yes.
Okay.
It's not like they had to go find it. They already had it. They gave it to me.
So there was an email and eventually they produced responses from 20 some departments.
Yeah.
And
Could be more.
eventually with attachments.
Right.
I would also note that even though actually, here's another question. The number of pages in the attachments to our file are quite voluminous. I'm curious if these records came to you in this exact format, or was it our production for this meeting that causes some of the pages to be totally blank?
Oh, no. It was fine. No, the attachments are fine. Yeah.
Are these the exact attachments you got, or?
No, these are formatted in a different way.
These
for
are
printing,
formatted.
I think. Yeah.
So
the Excel spreadsheets you got as spreadsheets, not as PDFs.
Right.
Okay.
I'm
So
pretty sure. No, they came as PDFs, but they were formatted nicely. They did not look this way.
Okay. And Mr. Darmali.
Yes.
Yes. At what point did you get involved in this?
I'm not sure about the exact, I don't know if I could give you an exact date.
Mm-hmm. I guess, was it
but
before or after the attachments were sent?
I was the one that closed out this request.
Okay. So you meaning closed out after the attachments were sent?
Closed out in terms of yes, the attachments were sent, and then I was
right.
said this is now closed.
Okay, this is now closed. In retrospect, even though I know you weren't the one who initially responded to this, if we're talking 22, 25, even 28 emails, if somebody submits a request asking for responses to a particular emails and it turns out to be fewer than 30 emails with attachments, does that seem like something that could be responded to as an IDR?
Well, it's hard to give one blanket answer because it's considering is there a privileged attorney-client communication? Are there aspects of this that fall within draft exemptions? I mean, I don't know if I can give you one answer for that.
Okay, so we can all acknowledge that the number of responsive records turned out to be small, but you're saying that you would still need the contents of those records would need to be reviewed in order to determine whether it would be a routine response or not a routine response.
If we need to consult with another city department or our deputy city attorney, it's really about their capacity, and we're not their only office or department that our deputy city attorney works with. So it's really a case by case there.
I'm curious with the initial email and what was requested. And I know her last name begins with a K. I don't have
Kittler.
Sophia Kittler.
Ms. Kittler. Based on what her request was, you know what? I'm getting speculative. I think I'm going to stop and hand it off to someone else. Okay.
I think we've all had questions, so member put a brief question.
Yeah, just to clarify, and thank you, Mr. Darmley, for being open to this dialogue. I think that as Joe indicated, we're not making this a huge gotcha and he said, she said. I think we're trying to sort of noodle through this, and I appreciate your willingness. I noted that the original request from Joe was sent to both Mayor's Press Office and Mayor's, Mayor Sunshine Requests. We've heard from the police department, for better and worse, that they have their own system of press requests go to one office and public records requests, not from the press, get handled by a different arm of the police department. Is it your understanding or representation that requests from members of the press for public records get handled in the same way, in the same queue, with the same considerations as a similar records request from a member of the public, or are there actually two different tracks, for better or worse, in the mayor's office currently?
Well, not every requester identifies himself. They sometimes use pseudonyms or like encrypted emails. So we treat every request the same, and it goes through very similar processes. I would say some journalists like to include the press office just for visibility because they know they work with our communications team. So that is something that does happen, but there's not two tracks that requests go down.
Okay. So even if it were sent to Mayor's Press Office, it's going to get bucked over to the Sunshine queue. And this request coming from Joe Fitz at sfstandard.com, it's pretty clear who he is. He's not, anonymous at Proton Mail or whatever. Okay. That helps. Thank you.
Okay. Good. I think everyone's had a chance to ask questions, so why don't we move on to rebuttals for this? Yeah, see a hand from. Nope, he hasn't his hand up. Okay, so let's go ahead and move to rebuttals. It'll be 3 minutes each. We'll start with the respondent and then move to the petitioner.
Mr. Darmali, are you ready for your 3 minutes?
Yes.
They begin now.
There's not too much that I'm looking to add to this. I do want to thank you all again very much for your time. I think this is a new administration, so we have been fine-tuning this process to make sure that this is the most equitable and diligent way that these documents can be produced in a very reasonable timeline following the ordinance. I think, there has been some changes in how we do things, and we really want to make sure that this process is the best it can be for all parties involved. But I think it's still we still maintain this was not an immediate disclosure request given, the extent of what we've discussed this evening. But thank you all for your time, and I really do appreciate it.
Okay, thank you.
Thank you. Are you ready?
Oh, yeah.
Your 3 minutes begins now.
Thank you. Well, I just want to thank everyone for their really diligent questions and really getting into the weeds on it. I do appreciate that. And I want to thank the mayor's office. It's a pain in the butt to come in on an evening when you're already done with the workday. So thank you for putting up with that and putting up with all the different ins and outs of these requests. Even if this is a somewhat adversarial feeling process, I hope you guys as an office come out feeling that we just had a discussion among colleagues. A few things I just wanted to flag. I don't think in my time with this mayor's office or any mayor's office, but I guess I'll only hold this one to task. I don't think I've ever gotten rolling responses, and that's kind of a huge red flag. I don't think I've ever gotten a rolling response.
Okay.
And I think that's a big red flag. I could be wrong, but I am 90% certain I have never gotten a rolling response from these guys, nor have I gotten rolling responses from most agencies I've asked for them for, except for the DA's office recently. So that said, I think it is, to the degree that the complexity is there, I acknowledge it. Absolutely, there's complexity, especially in those attachments. There is complexity in those attachments. I fully give that. But I think to a certain degree, if you look at those responses, the actual body of the emails themselves, they're just dry budget discussions. And I think all it took was asking Kittler a few sentences of like, hey, is there anything too damning in here? No? Great, thanks. Send those replies to Joe. And the question before you is our rolling responses subject to IDR? If they have things that can be given immediately in a rolling response, should they be given immediately? By my mind, it's yes, but I leave it to you to ultimately decide. And the last thing I'd flag is that there was, not really a discussion. There was not really like a, hey, let me flag these things for you. These things are not, we could talk about narrowing this. That is a major part of an IDR. I've dealt with lots of departments, as I'm sure you all have in this. And one facet of those public records discussions I have always appreciated is when a public records staffer calls me up and says, hey, Joe Fitz, this IDR is too broad. You're not going to get your stuff. Let's talk about ways that we can narrow this together and work together so you get your records. And that conversation can be less than 10 minutes. It can be less than 5 minutes.
30 seconds.
So to some degree, somewhere, there are some parts of this process that we can improve, and I look to you for help in improving it. Thank you.
Thank you.
Okay. Thank you. Okay, members, where are we at on this one? Member Sugarman, go ahead.
I just want to say I'm kind of on the fence because, like, on the one hand, I do genuinely believe that the lower part of the request does not make it a simple request. But in reading both the request and the mayor's office's response and listening to the mayor's office, it all kind of sounds from both parties a bit boilerplate. Like maybe that's how they're all treated. And it's like, for me, I don't, there's not enough, I don't have enough data in front of me, like to say how, like what Member Kumar was asking, like how these other cases are, how these other requests are treated. When that question came out, I was like, oh yeah, well, I want to know too, but that's not information in front of me. I will say, I wanted to add that I'm a bit flummoxed to hear of any city agency say that they are not used to getting a request with a deadline attached. I've personally, I can't remember that happening in any public records requests I've made for any story that I've had. Usually, I usually take a more softball approach to it, and I will just make a request, and usually the first response is, let's narrow that down, and what's your deadline? Like that's usually, they ask me that. And I'm waiting for another member to kind of weigh in, because for me, I feel like it kind of goes both ways. And you see it a lot in these cases, not like for journalists, but for anyone, where if you do submit a simple request that's legitimately just, can you please provide me this? Then you're going to get a back and forth from an agency to narrow it, and it's going to take a long time. And if you submit a specific request, then you might get something from an agency that says, this is not a simple request. It's not, you can't have it immediately. I want to make one more point, because I do think that the petitioner makes a good point about the rolling basis and 6725. In reviewing it, I think that that's only 6725D, having to do with the rolling basis. In my interpretation, that's only if we determine it is an IDR. If it is an IDR, then they're entitled to a rolling basis. But like, other than that, it's like, it doesn't say that, well, if it's not an IDR, that we're still going to give you rolling documents. Like, I don't know if that's a requirement.
Member Pelpel, then Member Levit.
Several topics. In part to Member Sugarman, I wasn't prepared to debate the broad or narrow scope of a rolling basis, just that when so requested is the language in there. And in as much as Joe referred to that in his second boilerplate paragraph, I think he invoked it. So I think
that's true. That's fair.
Yeah. Despite the collegiate, despite the ambiance, I actually feel like there are potentially a few violations here in the area of 21A. Let me see if I'm getting the right citation. One moment. No, 21B, 10 calendar, or excuse me, 10 days. 21C, assisting. 25A on an IDR, if it's a simple, routine, or otherwise readily answerable request. And one can debate whether this is. I tend to think yes, in general. And 25D on a rolling basis. Bottom line is, however this was handled by whoever handled it, I do not think it should have taken from April 28th to June 5th to get the subject attachments, which were requested also in one of the big boilerplate paragraphs, as relates to current year budget and specifically contracts and grants that the mayor's office had just asked departments to respond back with a list about. It wasn't that they were compiling something new. It wasn't that they were doing original research. It wasn't any of that. It was, you just sent out a memo to departments asking for blah, blah, blah. I would like to see a copy of departments' responses to that. It's current events. It wasn't that, one sec, it doesn't seem like it was actually that voluminous. It wasn't a lot of research. It was actually, I think, simple, routine, or otherwise readily answerable. And with redaction notwithstanding, city attorney notwithstanding, I have not heard before, and I like to listen for these things, a department saying, any records request we get, we have to run by the city attorney, and they're all backed up, so it may take a while to redact, so that'll take us some time. I don't think, if you get an IDR, you got to treat it as an IDR unless it isn't. And if it is an IDR, then you got to get somebody on it to review for redaction if you deem that redaction is important. And other than a couple of cell phone numbers, it doesn't seem to me like there needed to be a whole lot of redaction here. So I'm inclined in that way, but I'm open to persuasion.
I just have one question before Member LaHood, just one thing. If it wasn't an IDR, then when would it have been to have been turned over to him? Like what would have been the timeline? I'm asking anybody who has that.
Well, it would have been, let's say it was under 6721, they would have had 10 days. Presumably there's some debate about whether or not they can invoke a 14-day extension.
Right. And
even if they did, it'd still be on that.
And they didn't invoke an extension after 10 days.
They did.
No, they said they would. I saw the email that they said they would. But did they, after 10 days, come back to you and say, I didn't see that if it was in the packet, but they said in their response, it's going to take us this much time, and it might take us more time.
May 19th, it's on the first attachment, page 2.
Okay.
It says we were working diligently to produce all documents for your request dated May 9th, but strangely enough, it wasn't May 9th, it was April 28th.
That still seems after the deadline.
They treated the May 9th clarification
As a
and
new request.
re-request for the attachments as a new request, even though the attachments were referenced in the original April 28th request.
Shit,
That
I didn't
seems
even
like a
catch
problem.
that. That sucks. I didn't even realize. I didn't even catch that.
Remember the hood.
Yeah, I'm going to say I could be persuaded, even though given the number of emails and attachments that we're talking about, I could be persuaded that perhaps this was that this could not be responded to as an IDR within 24 hours, but I think it could have been responded to in 10 days. And even though I know this wasn't part of the complaint, I question these redactions, and I definitely don't see annotation on them. And for the ones that I can tell what they are, I think a lot of them were redacted inappropriately, and some of them are just baffling, where it's just a block of black text and it's inexplicable. And then other things where just because somebody doesn't work for the city like all of these contacts were redacted. Just because somebody doesn't work for the city doesn't mean they get to remain anonymous. In fact, I think we do need to know who they are. Maybe you could argue that their cell phone can be redacted, but I think but the name and the work email and who they are should be public information. And I think this could have easily been handled in 10 days and reviewed sufficiently. So I am persuaded to say that there have been violations.
Yeah, I'm kind of along those lines. I'm seeing personally, I think it should have been 10 days, even if it wasn't 10 days. It was
way more than 10 days.
Way more than 10 days, right? And even if you add a 14-day and this, that, and the other thing, I mean, it still went way longer. So I absolutely think, at least from my perspective, I'm seeing a 6721B. I'm not entirely convinced. It sounds like Member Pilfellows, that it could have been in 24 hours. That seems a bit of a stretch because you don't necessarily know what the attachments are.
Should have been a response with.
Well, they did
Yes.
respond in.
They did.
Yeah.
So I don't think that. So I'm seeing instead something more along the lines of a 6725D. I also think waiting till everything was done and then one big thing was. So those are the two violations I'm seeing: a 6721B and a 6725D. Personally, Member Schmidt.
Yeah, I'm pretty much on the same page. I do think we should with 6725, this case sort of points out a question in my mind that I've had is if the request includes some simple, routine, or otherwise readily answerable request information, but other information that's going to take some time. I wonder if that makes that whole request simply not qualified anymore for 6725. So we would look at it as now a 6721 case. Or can we say that, well, if parts of it are simple, routine, or otherwise readily answerable, then those should be answered according to the statute within a day. And then for those things that are not simple, either they come under the rolling basis or maybe we look at a possible 6721 violation. And I'm inclined to think that every aspect of this request that did fall into simple, routine, or otherwise really answerable, that I think they get what we would consider IDR treatment. I think they should. I think that there's definitely 6725 violation here, and I would certainly go along with 6721 violation myself.
I'm sure you're right.
I would support that 6721 and 25D. I don't think this is also a question for Member Schmidt and for the board. I don't think you can bifurcate a request. Like if it's like this is an IDR, then it's an IDR. Like if the entire request was an IDR, which is how it was stated, then you can't treat part of it as this is an IDR and these parts are a standard request. Would be my only consideration.
And that's sort of the question. Should we, in this little world that we're in, should we think of it that way? That, okay, well, that's not simple. So it wasn't we're almost saying it wasn't an appropriate 6725 IDR. And, there might be some things where it's all really complicated. And so clearly none of it would fall under 6725. But I'm just sort of throwing out the idea. is it possible that we can treat some of it as you got to follow IDR deadlines, but if there's something else that, turns into something more complicated, then that doesn't pull it all out of the 6725 treatment. I don't know. I don't know. I agree with you that was sort of the way I was thinking of it maybe before today, before we sort of started looking at this specific case.
Mr. Chair.
Go ahead, Member Wolf.
Yeah, I agree with Member Sugarman on this, that it shouldn't be bifurcated. Treat an IDR as an IDR, the way the petitioner has presented it, and that the provision to provide on a rolling basis doesn't make it a requirement that the actual documents be provided within 24 hours. It's notice that needs to be provided within 24 hours. And then if it can't be completed, then that's what the purpose of the rolling basis is. I mean, I go back to always the example I give, which is you're in litigation and you need something by, within 2 days. You get an IDR with the city, you try to get as quick a turnaround as possible. That's the kind of the purpose of using an IDR in this case, in that kind of way. Or if it's somewhat some state of emergency of some kind, like with COVID and what have you, reporters and journalists need the information as quickly as possible. So I don't see a need for reclassifying the IDR as a standard a request. I imagine the IDR was presented for the purposes of getting a timely response so that timely reporting can be made. I'll stop there.
Thank you, Member Wolf. Member Popo.
Yeah, I'm not sure that we need to reach the question of bifurcating an IDR. I can well imagine that something that's properly crafted as an IDR says, can I have a copy of last week's budget memo? And by the way, how about the entire history of Muni or the Hetch Hetchy water system or the Calaveras Dam replacement project? And a department might properly say, I can get you the budget memo from last week in 2 seconds, but the whole history of the Calaveras Dam, that might take a couple of days. Give me a moment on that, right? But I don't think that's before us today. I think that there's enough consensus that I've heard so far about something in the area of 21 and 25. And the reason that I mentioned 25A, it's just the last sentence. Maximum deadlines provided in this article are appropriate for more extensive or demanding requests, but shall not be used to delay fulfilling a simple, routine, or otherwise readily answerable request. So I interpret that to mean that you can't put off, that you can't convert, and that you can't treat a simple, routine, or otherwise readily answerable request to a regular request with all of those deadlines, that the import of an IDR is maintained, and thus you provide documents or records as soon as possible, so long as they are simple, routine, or otherwise readily answerable. And I think this is all in that intent. So I think we're in the 21 and 25.
I'm persuaded by members Wolf and Pilpel on 6725A and D as being appropriate in addition to 6721.
Something.
Yeah.
21.
Yeah.
I'm not sure. Personally, that's fine. Maybe I'll be, if that's the motion, I'll vote against. I'm not sure I see the A part.
I don't
personally.
I
I
way
don't
on that.
care as strongly about that. I just
I
think
mean-
there are elements of 21.
I mean, because I think that starts to get into the bifurcating question. I think it's an excellent question, right? And the way I look at it is, let's say that you ask for something that's going to have 30, 50 responses, right? And you get to the first two and they're complicated, right? They have a lot of attachments, a lot of stuff you have to go through. You might not know that maybe number 15 in the sequence was something you could give over within 24 hours because you spent so much time on number 1, number 2, number 3, number 4. So I'm not sure you necessarily could easily, in the example you gave with the memo versus something else, maybe it was more easily bifurcated. But in this, you might not know which responses had complex attachments that needed to be redacted. Now, granted, they didn't send any of the attachments right away, so that's kind of odd. And then tried to act like it was a new request. So I do have some concerns about that, but nonetheless, that's why I'm not seeing the A as much, because I'm not sure what was simple, routine, or otherwise readily available.
Right, because it would take time to figure out which of these.
Right, you'd have to
yeah.
go through the whole stack and segregate them, and you might not even get there. So that's why for me, it's more of a 25D and a 27B, as far as I'm willing to go personally, but others may disagree.
I just want to say I agree with you. I wouldn't go to part A of 6725 for similar reasons. And I can see what is immediately available. I can see what parts of our IDR. I'm just not convinced. Like I would like to be, but I'm not that for me, yeah, I do think it's possible that they used a 10-day extension. Like that was it. But we only have this one request in front of us to judge that by. So I'm not convinced that that's immediate without knowing more.
And I'm not so wedded to 25A. I can live with that one
I'm
or
good
the
with
other.
D.
I think my point was that either way, it wasn't within 10, it wasn't within 14, it wasn't within 10 plus 14. I don't buy we're taking the May 9th clarification as triggering a whole new
And completely
thing.
agreed on
Yeah,
that.
I agree on that.
Yeah.
Yeah.
And something else. Doesn't matter right this second.
Okay.
And I think we agree that the original request had a subject line, immediate disclosure request. So it had magic words and all of that. And despite the boilerplate language, it was all there. The elements were there.
Yeah. Okay, so does someone want to try a motion?
Don't.
Oh,
Go ahead.
I'm sorry. My other point was, in particular with IDRs, where they're complicated or where there are issues that arise, that's exactly when a department should come back and say, we need to clarify, focus, narrow, or prioritize. It's not we discerned however we discern that what you really wanted was item 15 and we didn't get to that, because that's when you interact.
I think that's it's agreed. I think that's also why this to me smells like, especially because they have a Sunshine request email address. Like it's like they're just like, well, we're not accustomed to this sort of request. It's like, I don't really see it that way, especially like they didn't try and manage it. I agree with that. It looks a little like it was a bit of a stonewall in that way. I just can't say that it was IDR.
So is the emerging consensus somewhere around 21B and 25D?
That's what I suggested, but I don't know if
Okay.
that's.
And whether or not there were other elements, at least that works. Send the message, et
And
cetera.
27B, because the withholding was, there were obviously things that were withheld that did not need to be withheld.
I don't think that was
You know-
part of the complaint. We didn't really go
So
into
even
that.
though we see it, we should ignore. Okay.
I mean, that was going to be
Okay.
open. I mean, I didn't get
Okay,
into.
take it off, take it off.
Can I amend my complaint and add it?
I mean, I would say you can certainly submit a separate complaint because we didn't consider that issue. So I would resubmit at this point.
Or we could just acknowledge in discussion here that we've advised the mayor's office that better justification or more minimal withholding is a good idea without having to go through a whole nother.
Quickly, so we can move along, because we still have another complaint and several other items to get through. Mr. Marley, if you're still over there, do you recognize the concerns we have with the exemptions and the redacting that's going on? I think most of the task force members see some, if not many, of those being as inappropriate. Is that something the mayor's office perhaps would have done differently?
I'll definitely have to take a closer look at that, as I wasn't prepared to talk about the withholding, and I'm not sure who was responsible for those portions, but that's definitely something I will take a closer look at.
Okay.
Okay. So we've at least had that communication. All right, so
Do you want to move 21B and 25?
sure, I'll move it then. I mean, all right, I will make a motion to find a violation of 6721B for not providing records in a timely manner and for 6725D for not providing records on a rolling basis.
Second.
Okay, seconded by member Sugarman then. Okay, let's go to public comment on that if there is any.
Anyone wishing to make public comment on item 14? No, yes, item 14, file number 25034. If you're in the room, please approach the podium. If you are online, please raise your hand in the app or press *3. This is public comment on item 14, file number 25034. We have no one in the queue.
Okay, I'll close public comment and let's take the vote on that motion.
Taking the vote on item 14, Chair Yankee.
Aye.
Chair Yankee, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland, absent. Member Pilpel.
Aye.
Member Pilpel, aye. Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Stein, absent. 3 absent, 7 ayes.
Okay, that motion passes. Thank you to both parties. We appreciate it. Okay, Member Wolf, would you just like us to take a short break?
I would appreciate that.
Okay, how long do you need?
I like 5 minutes.
Okay, so let's 8:20. We'll come back. So about 5-6 minutes here.
Microphones are off. We are in recess. Microphones are on. We are back in session at 8:19 PM.
Okay, and I see all of us are back here, so everyone except the aforementioned absent members are back. We still have quorum, and let's move on to the next item, item number 15.
Item 15. File number 25039. Complaint filed by Eric Roussel against the Capital Planning Committee, San Francisco Planning Department, for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. On June 17, 2025, the Complaint Committee found that the task force has jurisdiction, that the required records are public, and referred the matter to the full task force for consideration of a violation of Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner, whether names were improperly redacted on this document, and whether there are further documents to be produced.
Okay, and do we have the parties with us today?
Respondent notified us in advance that he would not be present and that the response submitted previously will stand. We also received
This was the respondent you said will not be present?
respondent,
Okay.
Mr. Jonas Ionen. Also on Monday, additional documents were produced by respondent, and they were sent to each of you in advance, and copies are available here in the room. They were not produced as part of the packet.
And you're the petitioner?
Yes.
Okay, great. Thank you for joining us.
Can I do disclosure?
Go ahead. Member Pebble has a
Okay,
disclosure.
so just a brief disclosure, I didn't notice this until I looked through the supplemental documents provided in the last day or two. There were several references to Brett Gladstone and his firm. I have known Brett for many years. We worked together on projects a long time ago, and I'm familiar with his firm. I had nothing to do with this particular matter. I believe that I'll be impartial. I have no bias, and I'm open to.
I never heard that name.
It's back here in some of the NOV documents. In any event, I'm just disclosing that I know him anyway. I have no bias in this matter, and I'm open to hearing the case.
Okay, thank you. This went to the complaint committee, so Member Schmidt.
Yes, this is not an IDR, okay, and it shouldn't have been, I mean, it couldn't have been, but it's a fairly straightforward document dispute. The petitioner went to planning and asked for a lot of quite a few documents on a lot of or on several different projects, and the production, I'm not sure if it went fast enough. That seems like there was delay. And at the time we had it in committee, we were told they were still working on some further production. The petitioner has stated that there are many categories of documents that have not been produced. I will mention that Mr. Ionen also was unavailable for the committee, and I understand sometimes you know, you can have a counter conflict, but we may want to be concerned about the non-presence of the respondent. The last thing is that one part of this is a question of whether information about a complaining party, there's someone named Kushner here, someone who complain about certain legal violations, if that can be information about that can be withheld as private. And there's certainly a dispute about that because certain of that information was withheld, but we can talk about that later.
Okay, I think we'll probably get started then.
One clarifying question. There's reference in the header and in one or two other documents that this complaint is against the Capital Planning Committee. The city has a capital planning committee, but all of the documents I've reviewed relate to the planning department. Is it Mr. Roussel?
Yes.
Did you have any issue with the capital planning committee, or is this strictly about the planning department?
But it's against the planning department of San Francisco.
Okay. All right. So maybe it was the CPC that somehow got translated into something else. So if we could just recaption this as against the San Francisco Planning Department, I think that would work. Thank you for.
Okay, so we're going to start. You'll have 5 minutes to present, and our administrator will let you know when you can begin.
All right. I made my sunshine request April 16th, and we're like 3 months later, and the real documents, records I was interested in have not been produced, such as an email from a planner at the San Francisco Planning Department that is calling me slimy. And this email seems to have traveled across the department with attachments with other CC people. And I've been asking for the thread of this email, and they've been reluctant to provide anything. After 2 months, they give me the attachment that one email had about on that thread from my neighbor. Actually, the complaint, the bad neighbor, Mr. Kushner, had became aware of that that email, and he took it upon himself to thank Audrey Malone, the planner, to qualify me as a slimy guy, and he said, "I agree with you, and I'm sure hope your colleagues will be happy to hear about me, my opinion." And so anyway, I asked about this email, the thread, nothing. I asked also about two enforcement situations that were very unfair to me about why it was done this way, and I'm still waiting for the records. One is for the notice of violation that was given to me for not complying on December 2nd, 2024, and I was actually in the process of getting my application done. I got my application approved on December 6th, 4 days later. So obviously I was complying somehow, yet I still got this NOV given to me. Another thing, my neighbor made another false complaint that's been deemed determined false by GBI and planning, yet it escalated into a suspension request for my my project there. No complaint. The complaint was false. There was no nothing. Yet they escalated that to a suspension. So I'm asking for the documents about that too. Nothing. I would like to also. I realized it's even worse. The emails that I have some copies for you, if I can provide. I have all these copies, and you can see that they have redacted the subject line, the CC line are not there. And on the last page, you have the email that my neighbor wrote to Audrey, and you can see the difference that we have. He has the subject and the CC, and he took it upon himself to provide a PDF of conversations of February 2024 about A74 fail, my place. So he made a PDF of emails, but planning has told me like 3 days ago, I provided everything. But if you look at these 3 emails that you provided me, in it you have Audrey Malone saying, I sent Rogelio a bunch of documents about the carriage house, which is my project, even though she has nothing to do with the enforcement case. When Rogelio, my enforcer, asked Audrey, oh, do you have any pictures of the place you inspected 10 years ago for? So there's some weird thing, and that explains to me why Rogelio, right from the beginning, has been very belligerent, negative, would not listen to me whatsoever. It seems like he's been influenced
30 seconds.
Other parties, like my neighbor and Audrey Malone, who calls me slimy because I don't know why. We just had an inspection 10 years ago, and somehow she don't like me. But I did nothing to her. Okay, can I please put that on record? His email with no redacted, with no subject lines, no CC.
That concludes your time.
Removed, so you have no idea.
That concludes your time, please.
Thank you, sir. We don't typically take late submissions like this at the meeting. They need to be in the packet unless the task force votes to accept them.
My understanding is that anyone can submit information. We don't have to review or consider it. But if someone submits information, whether it's a party or a member of the public, that we can take it and distribute it, and we can choose to ignore it. So if you go to a hearing, you can submit whatever. It would be distributed, it would go in the file, but we're not necessarily going to consider it because it wasn't provided timely.
Okay, I mean, the concern being that both parties aren't able to review evidence in a timely
Again,
way.
which is why we may say, and we may have other questions for planning, and if planning's not, whatever. I would argue that we take it, distribute it, and then we don't have to consider it. That's just my view.
Yeah, I was thinking about just emailing it this afternoon, but I thought it'd be more proper for me to.
I think it should be, if the task force wants to vote to accept it, I think we can do it, but we have a deadline that we.
I understand.
I don't feel comfortable.
If a member of the public brought it, we would take it.
We would show it on the presentation screen, but I don't think it's appropriate to, if people shouldn't be submitting late evidence that the other side doesn't get to.
And I'm saying
consider.
We would take it, we wouldn't necessarily consider it.
Well, it's their evidence. They gave it to me. It's planning's evidence, and I want to show it to you because it's kind of.
I don't care that strongly.
What's the date of that document?
This was sent to me like a month ago, and.
Who sent it to you?
Huh?
Who sent it to you?
Planning.
Planning.
It's in the record request, yeah.
Okay.
Yeah.
Okay, and it's a document that was not provided to the task force before.
You might have it somewhere, but I just realized
We might have it.
The CC and the subject lines are gone. I should have realized that right away. So now I want to point it out. Yeah,
Example of redaction. That's what he's doing.
Trying to hide something. If he took the subject line out, is because most likely it said something disparaging to me about me, or if he took the CC line out because maybe somebody else in the planning department was. So I just want to point that out. It's in the file.
Something was blocked out on it, redacted, blocked out. On the CC line, correct? The name. Is that what you're saying?
Well,
but that's a document where we have a version that has.
I think you have you have a copy of that. Yeah.
Okay. Thank you.
Okay.
But we already have it, I think.
If we have it in our packet, we can certainly consider it. And you could point us to the page number, but
yeah.
Our complaint procedures are very clear about what the process is, and it's not taking stuff during the meeting.
Oh,
No, sure.
no, there are two pages you don't have because it provided me with the attachment that Mr. Kutchner used when he emailed them. And that attachment actually seems to be redacted because the title of the attachment is 20 February emails 2024 of A74 fair. And there's only the same emails that that email is sending.
I have a question.
Go ahead, Member Schmidt.
There's a new production that came from the planning department that's over 500 pages. Did you receive that just in the last several days?
I received something, but it was not like it was not 500 pages. It was more like.
Okay, we got something provided to
Yeah,
us. It's just in the last couple days, and I just want to see what is. Have you gotten that, Doc?
Well,
Have you looked at it?
I got something. Yeah, the plane said to me, "Here, oh, we forgot to send you this." Okay, so I got something. Yes, maybe
Okay,
that's the same thing.
Is it possible that you haven't quite looked through it to see if they've given you everything
No.
that you asked for?
I did look into it, and
You did?
there is no no. What they sent me in a zip file, which most likely is the same thing as that.
Okay.
I looked through it because I was like, okay, maybe I have the mystery of the thread, the email disparaging me, and nothing of that. And also, I want to know why the suspension request was imposed on my carriage house when there was no reason to trigger this, and also because the ZA was about to determine my carriage house to be good to not be suspended.
Well, are there any documents that you can tell us you think were not given to you at this time by planning department? I'm not asking you to say, well, there may be documents out there, but is there anything that you can tell us what the document is that you have not received?
Well, easily on here you can if you read the text.
But you received that, right?
There are like 20 more emails, it seems.
Oh, so that refers to other emails.
One email.
Okay, so
I sent some email to you, but
there's emails that you've seen referenced in the documents you received, but you've never been given those emails. Is that what you're saying?
some of these emails respond to another email, and that is not here. And some
Not here.
Right.
Just real fast, because I think
Okay,
it might
thank
be
you.
important for this to your point. So obviously there was that huge stack, right, that was provided on June 30th, right? That was also a late submission. That was on behalf of the respondent. So what I want to give you as the petitioner is obviously that you got the 527 page attachment on June 30th, right? That does not give you adequate time to look through that to see if everything that you still feel is necessary is there.
I looked through it in details because
Okay, so just, sir, let me finish real fast. So what I was going to offer to you is if, and you don't have to take the offer, but I just want to make sure that you know that's there, is if you feel you need more time to review the full 527 page attachment that was provided to you on June 30th, it's typically the practice of the task force to grant a continuance. If you say, you know what, they provided this last minute, I'm not prepared to speak to whether or not that attachment does or does not contain everything I was still looking for. I just want to give you the opportunity to ask us to continue your item if that's what you want, and then we can pick up where we left off next month if you need that additional time. So I just wanted to put that out for you.
And no, I don't.
You do not need a continuance.
I don't need more time because I checked, and it's definitely not having the thread here. You know, you can use AI and search words, it has nothing that I request. It's same story. We provide documents at the last minute because I'm going to court, and otherwise no rolling production, nothing. So
Okay,
Is
so
this
so,
a-
so you're not asking for a continuance to
No.
review the document? Okay.
no, because I know it's not there,
Okay, all right. Member Popo, you have some questions?
and it's very important. I mean, because
No, sir, I understand, but
sorry. Yeah.
this is now the question and answer time, so we're asking you to please only answer the questions that we're asking you. We gave you your 5 minutes to speak and we
Sure.
didn't interrupt you, so we would like you not to interrupt us when we speak, okay? Thank you. Member Popo.
Okay, so I'm troubled that planning is not here. Some of the questions about compliance are best directed to planning. I understand Mr. Ionin was unavailable. I don't know if Chad Bury-Son was available, but in any event, the planning department, and I'm not telling them who and how, but they should have somebody as a backup for Mr. Ionin. Whether it's a departments larger and smaller have backup people, and it's important for them to have not just one person, even if that's the point person, they need to have a backup person, and not having them here is problematic. I don't know if it's 21E problematic, but it is problematic. I want to make clear to Mr. Roussel, is that correct? Trying not to use my French, but I got that. We're concerned with meetings and records, and in your case, records. I don't think we're going to get into the minutia of the planning department or DBI or zoning administrator determinations or notices of violation or any of that. That is between you and the city and whoever and Mr. Kushner and all of that. Not my particular concern. I'm sorry. The planning department in their response to us, page 113, if you're following in the packet, talked about redaction and withholding. And that's something that we've been concerned about. And I'm hoping that Member Schmidt will get in on this as well. There are different issues that apply with regard to withholding and redaction of names as relates to these types of property-based complaints. And unfortunately, it doesn't cut very neatly that you can, you can't, you have to, et cetera. It's kind of all over the place. And so I'm trying to understand if your primary concern is about documents and whether you've received the whole universe of documents that you've asked for. And clearly you asked for a range of things, and the department says that they've provided a number of things. Whether or not they were timely and whether or not there were errors, we can get into, or if your concern is primarily or includes this issue of withholding and redaction. Can you tell us what?
I don't care so much about the redaction because I
Okay.
know it's my neighbor is the one in black all the time. And by the way, he disclosed publicly his name himself. Like 3 days ago, he said, "I'm the complainer. I made like all his complaints." Did you get that on the
Yeah,
stuff?
I saw that.
So
It's in here.
So he disclosed his name, but when he emails Audrey, not as a enforcer, as a public member of saying, "Oh, Audrey, I agree with you. Eric Roussel is an Islamic guy. He doesn't deserve any redaction when he's in this capacity here." So, and when he sends a PDF attachment in his email, he doesn't deserve any redaction, anonymity for this. So I would say that he lost his rights to be anonymous, especially because 3 days ago he decided to release the whole thing. "Oh, I made this complaint." And by the way, he complained about way more. He spent all of his years emailing the planning department, DBI, complaining about me, and constantly asking about my my permits, it's crazy. It is like thousands of emails. I'm getting this ready. I'm gonna have a report pretty soon. But the guy is obsessed with the reason is to
Okay, we need to keep
I understand
question and
that.
answers on topic
Let-
here. So
Let me try to rephrase. So your 2-page document that we have right at the top on page 5 from you to us dated May 16th, where you summarized the situation, 1, 2, 3, 4, 5 with requested relief. Is this still current? Is there any update to this? Is this
it's
still what you're
supposed to be
looking?
April 16th.
No, it's dated May 16th.
Yeah, but it was my request was the
What-
April 16th.
That's correct.
And I stand by this, where I asked about, specifically I asked about the Audrey Mellon email on that May 16th request. That's what actually triggered me to do that. That sunshine request. And I still don't have the emails that are referred to in the messages that are in the release emails to me. Audrey says, "Oh, I sent you a bunch of email with documents about his property."
Okay.
And he's asking for
I'm
pictures.
just gonna try one more time. This May 16th email from you to us summarized why you were filing the complaint with us against planning, and there were specific things that you were looking for or you believe weren't provided. Planning responded to us dated June 10th, explaining their position. They're not here. You are. This is your opportunity to respond to their response to your contention. What can you tell us about what you're looking for right here, right now?
Well, the same thing I asked for on June 10th, May 10th, April 16th, the email thread, because I think that there's some I need an ethics complaint. I want to file an ethics complaint because what is being going on between my neighbor and some internal staff at planning is not being properly done. And that's why I'm asking for this email. That's why I'm asking for these documents. And the enforcement that was done in my case about my notice of violation for not complying when I was actually complying, when my building was suspended for a false complaint, I need these documents that I requested, and planning is not providing it. And it's the same thing that I requested before.
Okay, I give up.
okay.
And if it don't come, it's their fault, but they should be.
Okay, thank you, sir. Thank you, sir. Anyone else have questions? Okay, we're going to move to the rebuttal stage. So you have 3 additional minutes. You can use it to speak anything you want about the case, since obviously there isn't anyone from planning to necessarily rebut. So our administrator will let you know we have 3 minutes.
Are you ready?
Well, sure.
Your time begins now.
I guess it's pretty much what I said. We were requested to procure these documents, and for the last 3 months, and they're still stalling and giving me other things. I made it clear, Audrey's email, because my inspector that actually planning agreed to reassigned was very belligerent, very negative of me, and I think it was due to the fact that Audrey contacted him, and somehow he decided to take it upon himself to do what Audrey wanted him to do, because he was really unprofessional, and so much that actually I want to file an ethics complaint. I want this is not right what's happening, and I just want the right thing to be done. Maybe a member of the planning department cannot just use his powers to weaponize them against me, against a member of the public. So yeah, I want you to find and the planning department in violation of the sunshine request. I want you to order them to release these documents right away. And I want you to, I respectfully ask you to please refer them for an ethics investigation, because it's not ethical at all what's going on at the planning department with my aspect ownership. That's it.
Okay, thank you, sir.
Thank you.
All right, members, how do we want to proceed on this one? I'll get the discussion rolling. I think it's problematic to Member Schmidt's point that this is now the second meeting in a row without planning department staff. It sounds like they were not there at the complaint committee. And to Member Pelpel's point, I mean, planning department's pretty big. I don't think it would have been too difficult to find someone in planning to come to at least one of these two meetings. So whatever we do, I would like to be supportive of something within the realm of 21E for not sending anyone here, because I think it's made this more difficult the process.
Comment.
Was that you, Member Wolf?
Yeah.
Oh, go ahead.
I was just going to say, you know, the mention of Mr. Ionin appearing, he's the secretary of the commission. He doesn't work for the department. So if this is against the department's PIO, at least, since every department now has a PIO that manages sunshine complaints, the PIO of the department should have been here, not Mr. Ionin. So, you know, let's keep clear the difference between the two.
Apparently, we've been advised that Mr. Ionin is the records custodian or is responsible for the custody of records at the planning department. That wasn't our choice. That apparently was their choice, and that's how he's represented himself.
Okay.
Member Schmidt?
Yeah, I agree that we should cite them for not sending someone, whoever it would be. They're not here and they weren't here before, and I think that's enough that we do that. And I think if you look at the fact that we're looking at documents coming in 2 days ago, we've clearly got delay, so we've got a 21B violation. I don't know. I'm trying to figure out what's outstanding that hasn't been produced. It does seem like in the belated production of 527 pages, they indicate that there's nothing further that they're going to be, that they think needs to be produced. But I think we could order production of anything remaining, partly because we don't necessarily have to consider the 527 pages. And it does seem like Mr. Russell has identified some documents that he believes have not been produced. So some type of an order that they produce anything further, I think, would be appropriate.
I agree with you, Member Schmidt. I think that sounds appropriate here. Obviously, if they're sending 527 additional pages 2 days before this, then clearly that didn't meet the deadline. And even though I asked the question, it still seems very difficult to go through 527 pages before this meeting and to parse out, is everything really there? So, you know, I think it makes sense to do that order and then, you know, send this somewhere for follow-up compliance. And hopefully that gives the parties, and then hopefully if there is a compliance portion to this, that we do have someone from planning to come who can address any, you know, outstanding concerns that were made.
It doesn't sound like this is as much of an issue now as it was maybe during the complaint committee hearing, but I think there was an objection to the redaction of the name of Mr. Kushner. I think that that doesn't seem to be quite as much of an issue. And it's my understanding, and I think that privacy objections we need to look at very closely. And I think that they're often made where they don't really apply. But I do think that if it's of a member of the public who's complaining about something they believe is illegal, that is an appropriate place under the law, that type of information can be properly redacted under the privacy provisions of California law. So I even if we were being asked to say that there's excessive redaction or somehow that information not coming through, I don't know if I'd want to order anything in terms of overriding those privacy objections.
I would just weigh in to say privacy balancing is not the old 6255 balancing, and I think it cuts in different ways. And unless, we're properly briefed on both sides, including by the department and perhaps by the city attorney, I'm not prepared to reach any conclusion one way or the other on the appropriateness of this redaction here. And if the complaint petitioner isn't making that the central theme of this case, then I'm not sure we need to get there.
I've moved that we find that respondents in violation of 67.21B for failure to timely produce the requested documents, and that we order that all identifiable documents requested that have not been produced be produced per the ordinance, and further that respondent has failed to have a representative in attendance in violation of section
21E.
21E. Thank you. That's my motion.
And we'll send that to a committee for follow-up.
And to send to a committee for follow-up.
Okay, we have a motion from Member Schmidt. Do we have a second for that motion?
Second.
Seconded by Member Wolf. Okay, let's see if there's any public comment on that motion as soon as our administrator is done typing it.
Anyone in the room wishing to make public comment, please approach the podium at this time. We have no one online.
Okay.
We have no members of the public online.
And no one here coming up to the podium. Okay, so we can go ahead and close public comment and move to a vote on that motion.
Can we read that?
Oh,
So
sure.
clear.
Okay, if you could reread that.
Moved by Member Schmidt, seconded by Member Wolf, to find a violation of 6721B for failure to respond in a timely and complete manner, and to order production of any identifiable documents that have not been produced, and produce them under the ordinance, and that respondent has failed to have a representative in attendance per section 6721E, and to refer the matter to committee for follow-up.
Sounds good. Okay, so when you're ready, Administrator Peterson, you can call the vote.
Taking the vote on item 15, file number 25039. Member Schmidt.
Aye.
Member Schmidt, aye. Member Wolf.
Aye.
Member Wolf. Aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland, absent. Member Pilpel.
Aye.
Member Pilpel, aye. Vice Chair Stein, aye.
Absent.
Absent. Chair Yankee.
Aye.
Chair Yankee, aye. Three absent, 7 ayes.
Okay, that motion passes. Thank you, sir, for joining us this evening. And we can move on to back to. So we left off at 5 o'clock or just thereafter. Item number 5. So just so the record is complete with what we're on, Mr. Pearson, would you mind reading number 5 again into the record?
Thank you.
Q.
Item number 5, hearing on amendments to Ethics Commission enforcement regulations. Discuss and consider taking action to provide feedback on the Ethics Commission staff's proposed amendments to their enforcement regulations.
Okay, so I think we left off our discussion with some of the concerns that we've had with the proposed regulations. And so I think we're kind of on the stage of, do we want to craft some type of response to the Ethics Commission, either in writing, authorize people to go, speak for them, some combination thereof, and what it is we think, what points we want to focus on. I think that's kind of where we're at.
I have a question, and
Go ahead,
forgive
Member.
me if this was said before. Can you explain where they are in their process?
Yes.
And what will happen next?
Right. So what happened is apparently there's been a months-long endeavor to rewrite their enforcement regulations. And there were notices sent out to what they have called an interested persons list, as people who've signed up to get notifications from Ethics Commission, right? And so these went out talking about they're going to have revisions on it. I think they did one round of it, got some initial feedback. Then did a second round. I know for the second round, Member Pilpel and I attended, gave feedback to the Ethics Commission staff. Unfortunately, they didn't have the draft available for us to review prior to going to that meeting. So we were just kind of speaking about more generally in the sunshine realm, what we think works and what we think needs to be fixed. In response to that, they drafted these amendments to the enforcement regulations that I think were on the agenda that Member Schmidt and Member Pilpel attended in June. It appears that not only was our show cause hearing continued, but any consideration on those amendments were continued as well to the July meeting of ethics, which I believe is going to be Friday of next week. So that does give us time to prepare a response and send it if we want. I'm not sure. I think Member Pilpel said they probably will not vote for final adoption on Friday. I don't know. I haven't seen the agenda. The agenda isn't posted yet. They just said in their latest email that it's going to that meeting.
Right.
It says they will consider and may take action on proposed amendments at their Friday, July 11th, 2025 meeting.
The way they had this package was that they were going to go twice, once in June to present, and then based on feedback from the commission to finalize and present a version for adoption in July. Unless they've compressed that down to one, then they would still presumably present once and then come back a second time, but who knows?
Right. So
either way.
It could be July and August, or it could be they're trying to do it all in July. I don't know. So that's kind of where we are. So I think to Member Schmidt's point that he was bringing up earlier, it's not clear to the extent the actual appointed commissioners have been involved in this process, have had a discussion, have had our concerns transmitted to them through staff. My personal feeling is that it doesn't sound like that's happened much, and that the commissioners may be receptive if we, as another appointed body in San Francisco, try to talk directly to them without going through staff, since I think we've been very diligent about trying to go through their staff, and that's been largely ineffective and unproductive in this process. I don't know if you agree.
I think that there's a real
Disconnect.
high wall to get anything before these commissioners. And that's just based on what I've seen in various contexts here. Certainly, I think the commissioners, anything that we can do that will reach them is what counts. I'm not sure if anything that gets stopped up with the staff is going to be of any effect for what we're looking for.
Well,
So
they
I
all
was
have
kind
email-
I'm sorry, go ahead.
They all have email accounts. And I think it'd be prudent to have a chair meeting. Staff does not need to be involved for something like that. And I think it's your prerogative as chair to be able to contact the ethics chair directly.
They don't publish their direct email accounts. I have written to their collective one, which supposedly should be distributed to them, and have directed whomever is managing that email box to do just that. Received a response only from VC Matthews when I tried to pursue that route to discuss and share our concerns with commissioners. Never received a response from the commissioners themselves.
Wow.
So we've tried that, and time's running out here. So I think at this point, if we're going to send something, it needs to be probably some type of official, to a certain extent, task force endorsed type of communication. Obviously, we don't have time to bring something back. So I think we would have to, if we approve a written communication, it would have to be approved more in concept, and then entrust one of us to draft it, and then some or as many of us as possible to show up, I think, and give public comment would be good. What I was going to say is I would propose that we consider it almost in kind of two umbrellas, and the first one being the willful portion. My concerns on the willful portion that we've talked about before is that it still doesn't provide us a working definition of what a willful violation is. So it's nearly impossible for us to hit that target if we don't know what the target is, and we don't receive feedback for when we do try to submit something other than this is a confidential memo, we're dismissing your case, right? And number two, I think it still does not do anything to put what we consider the most egregious sunshine violations that exist in front of the commission. And so for me, those are the two biggest issues that's missing from this. On the separate side is the elimination of the non-willful referral process. And I'm kind of mixed on that. Part of me feels that there may be some room under we could argue it's a general government ethics law, which the charter does give them permission to hear. Another argument I think can be made, it doesn't really, just because the charter gives them specific permission under a variety of things, the sunshine ordinance can be certainly supplemental. It doesn't prohibit them from hearing anything sunshine, right? But then I think there's also the broader point is that necessarily the battle we want to have, or if we include too much on that, does it take away from the focus of the willful? Because even if we were to go down that path, I think it's largely agreed upon that there's not much that they can do for a non-willful violation other than essentially redo the process that we've already done. They're not going to do something, they're not going to issue a fine, they're not going to be able to go to court, they're not going to be able to issue a writ, they're not going to be do anything on a non-willful violation that we here haven't done, which is issue an order, post something on the website and so forth. And so in some ways, should we consider, and I'm not sure where I land on this yet, but maybe we consider that as something, as a reason why when we consider amendments to the ordinance, maybe enforcing ordinances that aren't willful or enforcing orders that are not willful violations necessarily, maybe sending them to the Ethics Commission isn't the best place to send them to begin with, because it's largely a redundant process from what we do. And does that really serve the efficiency of both the city and the people trying to obtain the documents? So maybe this is where we say, hey, you know what, this is something we tried for 20 some years. This isn't the best way to have it work. So that's kind of my thoughts. I'll leave it there.
Comment.
Go ahead, and then Member Pilpel.
So this is not the first time, we've done this in this rodeo. I remember LaHood and I had tried many times to try to move something like this. We did get some leeway with the extra code sections in the ethics but they haven't really served us well. So one of the things that I had tried was, because the ordinance says to try, to report it to a body that has enforcement power, I started to go around and try to figure out who has enforcement power. So other than the Ethics Commission, you have the DA, and the DA didn't want to touch it. They basically said they don't do they don't do administrative stuff, even though they're named in the Brown Act and in the Brown Act. Public defender wouldn't do it. I don't know who else would be another body that could provide enforcement services to us at this point, other than the thing taking it straight to court.
And that's an excellent point, Member Wolf. And then, I suppose, are there things that if we were to have a amendment process for the ordinance, are there certain enforcement mechanisms that maybe we ourselves should request to have written into the ordinance? I'm not sure what those necessarily would look like, but I think if we can show we did our due diligence to try to find all those pathways that you just spoke about and how all of them have largely been dead ends, I think that only bolsters our argument for why amendments are needed. And so that's why I'm kind of leaning towards, I'm not really sure we should worry too much about the non-willful referrals over to ethics. I'm almost more, let's accept them being out of the game, because I don't think even if they technically wrote it back in, they were still going to do much enforcing on that round. Member Popo?
Yes, I think the discussion about amendments to the ordinance in this area are properly with CAC and whatever process we'll talk about later on. I think we should authorize a communication, and whether that's a memo or an email, and maybe the group to work on that is somewhere between Chair Schmidt, Chair Yankee, and myself, and we can collaborate on that in the next few days. And if we authorize such a communication from here, I think the main points should be willful versus non-willful, and having some language that explains what they do under 67.34 and what they do under 67.35D, with enough clarity and specificity and definitions to work, whatever that means, and that we can engage further to make that work. But in our view, the version that they put out by way of this memo and attachment is wholly insufficient. It just creates more ambiguity, doesn't clear any of it up. And that we're willing to discuss, engage with whoever, whenever, give us the time and place, we'll send our team, and that's fine. Something along those lines, relatively brief, relatively high level, and go from there. I suspect that their discussion on this is going to be animated in part by the handling of the Lotaki matter, because that's very much in front of them, and they didn't quite know what to do with it. And it really begged all of these questions of, what are you sending us? What are we trying to do? And you go and look here, there's some level of explanation, not a lot, and they're proposing to nuke most of that in favor of, I'm not sure what this says. So something along those lines, I think, would be in order.
I have another tactic.
Do you have some, Member Schmidt first?
Sure.
Go ahead. Oh, go. He says, go ahead, Member Wolf. I'm sorry. Go ahead.
Oh, okay. So the other tactic I have is to take up an issue that we find easily and clearly be willful that they will not act on, and file a writ of mandamus and let them explain in court why they won't act on it based upon the law.
Well, that's a great point. So I've actually asked one of our other DCAs, DCA Lopez, who's not here tonight, to explore, can we, as a task force, potentially file a writ requiring the Ethics Commission to take up or reconsider a willful violation referral that we did, referred over to them. And largely that discussion came about in their kind of brief dismissal of the police records, police chief one, which interesting, it went to court, was a file, and then suddenly once it made it as a court case, suddenly documents started to be turned over. And so I think that was an absolute, to your point, missed opportunity on the part of the Ethics Commission, because clearly when it ended up in court, documents started to be produced. And so I think that demonstrates a major failure of the process at the very least, where ethics could have stepped in and facilitated this when we did everything we could and instead didn't and let it sit for months.
Mm-hmm.
I don't know if we have an answer from the DCA on that yet, whether we have the authority to do that. Obviously, I've been involved in my professional capacity, using that process. There's a civil code for it, where if there's in our case, it was a civil service board decision that the agency that I was part of didn't agree with. And so we went to court, and Superior Court ruled and made the Civil Service Commission reconsider the decision they made. So that process does exist in some way.
Mm-hmm.
How we would use that, I think, kind of is still up in the air.
Remains to be seen.
Yeah.
Well, even just the threat or just the motivation or movement of going in that direction could be enough for them to, think twice.
Member Schmidt?
I'm not going to touch that one since I have no answer or strong opinion about it. I'm going to leave that one alone. There's a couple other things. One is I noted that one of you who went to the discussion about the changes, the amendments, you said that it feels like the written product doesn't look like what seemed to have been discussed.
Mm-hmm.
And I think that in itself that's interesting to me, because you got a sense in that way. That sense that you got, I think, would be in, I don't know if there's a way to point to different things and say, well, that doesn't seem to be, that might help us if we knew exactly how they differed, the discussions versus the result that actually got put out there. That's significant to me. The way I see the willful versus the non-willful is, I think that anything that maybe we would do from now on should be with the strategy of, we want to win on willful and we want to get as much as we can in terms of them not taking away remedies, et cetera, et cetera. But I think with the other items, maybe we can sort of make a half-hearted case. This, we do it this way, but maybe it's not the best thing. I don't know if 6735 really is about us. It's about somebody who brings their own thing before the Ethics Commission.
But they should have it addressed in their regs.
Oh, they should. They should. Yeah. And so we're, Yeah, we're sort of discussing their regulations in that way, but and it's about sunshine, yeah. But those are not the hill to die on for us. And if we sort of lose on these things that we're putting out there but not pushing really strongly on, then and we make it clear that the one we really believe in is the 67.34. That to me is the sort of the strategy that I think maybe we should be, that should be part of the strategy we should use. The last two things I'll just say right now. One is Member Pilpel, I wanted to highlight the fact that you said, yeah, these are ambiguous. And I really do agree with that. The way that the Sunshine Ordinance was written in these sections that it's really caused problems for years. And the ambiguity here is really bad. And so we're having to deal with that. Yeah. And so, but what you do with ambiguity is you just got to do what you got to do to deal with it. The one thing that I want to mention when it comes when it comes to the definition of willful, I've been doing some reading of cases, and I kind of feel like I've gotten it, like what I think we should assert should be the standard for willful. And this comes out of California law. Willful is a word that's used in a lot of different contexts. But this, I think, sums up in about 2 sentences what I think we want to convey and what we should be recommending to the Ethics Commission, partly because willful, you can think of that as being a real high bar, but I think that really willful, it's not that high of a bar. I'm going to read from, this is it's actually case law in 2013 refers back, and then I think a case that came out 2 years ago refers back to this statement in a 1940 case. It says, in civil cases, the word willful does not necessarily imply anything blamable or any malice or wrong toward the other party or perverseness or moral delinquency, but merely that the thing that was done or omitted to be done was done or omitted intentionally. It amounts to nothing more than this, that the person knows what he is doing, intends to do what he is doing. That's it. And so it's not that they specifically intended to violate the law. It's just that they willfully acted in a way that's wrongful. And so that's the distinction that you see the cases go into that distinction a lot. Do you have to prove that they wanted to violate the law, like it was egregious, like it was I don't care if I violate the law. That's not necessary for willful, I think. And so I think that's a definition that we can work with. Basically, they intentionally fail or refuse to perform an act which is required to be done by law. I think those are the last thing is, we could get something written in before they meet again in a week and a half. But it does sound like their process already got delayed probably by a month because they didn't even call the matter last time. So it may be that we should be looking at getting something to them between their next meeting and when they hear it again. Because it sounds like we don't even know what the commissioners are going to think of what the recommendations are yet. And they haven't heard what the public thinks about the recommendations. So I don't know if it's necessarily ripe for us to get something written to them yet. I'm not saying that we shouldn't. That's a good idea. But it may be that it's a little bit on the early side to have to get something in written.
And then you, Member Wolf.
Okay, and then maybe I'll come back after Member Wolf.
Yeah.
I've
And
got
just a time check, it's 9:25 and we still have a lot more to get through. So if we're going to take an action, we need to start getting there.
I've got a motion ready to go. Without debating the definition of willful, in this context, since it ties into official misconduct, I think of it very much like what I recall is the definition of official misconduct that's either in Madam Deputy City Attorney, either 15.105 or one of the ethics sections. Failure, it's something like failure to perform a required act or performing an act that is unauthorized, or failure to deliver at a reasonable and expected level of a public servant. There's some language to that effect. It's like falling below the expected level of your particular office. Something like that is official misconduct. And so this ties in to that concept, whatever language you use, and I don't have any particular objection to that. I was going to move towards a motion, but if you want to take Member Wolf first.
Member Wolf, do you have a brief comment before we move to motion on this?
Yeah, I was going to suggest that we take we make a motion or pass something that kind of for us enshrines what the definition is. And that way it's clear to whoever we're talking to that we have an agreed understanding of what willful means.
I think that may be one of the things that we asked for, but I don't know that we need to noodle through that tonight. So I was going to suggest, whether we do it or not, that we authorize a communication to ethics regarding their enforcement regulations, and that we specifically designate Chair Yankee, myself, and Member Schmidt as authorized to communicate and pursue the matter with Ethics Commission staff and Commission members directly. And we would do that in part based on what their agenda next week looks like. So we'll have that authorization, play it by ear, draft something, and decide next week whether to send it or whether this is still pending based on Lataki, whatever else. Anyway, something along those lines. Do you want me to formalize that? And does that work?
Yeah, I'm fine with that.
Okay. Pat, do you want to try relating that back, or do you want me to reread it?
Moved by Member Pilpel to authorize a communication to the Ethics Commission regarding their enforcement regulations, and that we designate Chair Yankee, Member Pilpel, and Member Schmidt to communicate directly with the Ethics Commission.
With the Ethics Commission staff and commission members.
I think that gives enough broad discretion if other task force members are comfortable granting us such broad discretion based on the conversation.
And we'll let you know what happens. It's not like we're going off into the dark, and it would be consistent with the discussion that we just had.
I do want to make sure that if anyone else who hasn't been as involved in this conversation has any concerns that differ from what the discussion so far has been, that you bring them up now so that we don't misrepresent everyone's views.
You're on the right track.
Okay. Is that okay with you guys too? Okay.
Yes.
Okay. So
I'll sell you out.
okay. So I just want to make sure that we're broadly representing all of our collective interests here. Okay. So it sounds like we are. So I think that's a good motion.
And I think Member Schmidt is on the right track with the definition.
Yeah.
Yeah, Member Wolf, I was going to say that I understand your thought on the definition. I think that generally this definition we can work with it, and I think it's safe to assert it. And so at some point, we'll get it down in a written form. But I'll be prepared to sort of advocate it and, have all the bells and whistles and citations, et cetera, to say to the Ethics Commission, look, we're not seeing that you have a definition, but I will say that under California law, the definition looks a lot like what official misconduct is under the San Francisco Code, because what Member Pilpel said to me, it doesn't contradict what I think is probably the general California not so high standard for willful.
If we just say we would like a definition and they say we have no idea where to start to come up with the one, we can say, here's a good example. Why don't you start from that? There you go. And
my understanding is that their staff has a much higher bar than what Member Schmidt just read to us. And I think that's great to show that that's largely what he's done.
Yeah, I would anticipate that their staff, in conjunction with their legal counsel, has a definition that is different.
I was getting the impression it was kind of like Nixon Watergate. Type
exactly.
Of level. And I don't think that's.
And I think it's safe to say that that's just not right to have that as a standard.
I also wonder if maybe HR or risk management might be helpful, because they might have to deal with these things with general staff on a regular basis.
We can point to and find other resources as needed, but I suspect that this has come up in the context of campaigns and other complaints that they already investigate.
Okay, so it's 9:30. We have a motion. Do we have a second for that motion?
Second.
Seconded by Member Wolf. Let's go ahead and open up that to public comment. And I don't see anyone online. So if there's any public commenters in person, please come up to the podium. If not,
Anyone wishing to make public comment on this item, please approach the podium if you're in the room. We have no one online.
okay. And no one's at the podium. We'll close public comment. I know there's still a little bit to get through, so I think it's okay to go ahead and move to a vote on that and move along.
Taking the vote on item 5. Member Pilpel.
Aye.
Member Pilpel, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson, absent. Member Highland, absent. Vice Chair Stein, absent. Chair Yankee.
Aye.
Chair Yankee, aye. 3 absent, 7 ayes.
Okay, so 9:34, Member Sugarman has left. So we still have 5 here, 6 with Member Wolf. So let's try to get through this as fast as possible. Item number 6, Administrator's Report.
I'm sorry, we're moving to Administrator's
6.
Report.
Item 6, Administrator's Report.
Item number 6, Administrator's Report, including Task Force and Committee tentative hearing schedule with potential adjustments, complaints and hearing requests, pending petitions and complaints, Sunshine Ordinance Task Force member attendance, and recent communications received in the last month.
Okay, so there's the.
Oh, not fireworks.
Yeah.
Yeah, that was a little scary.
That was a,
And I'll just reassure each other one more time.
yeah, fireworks, right?
I didn't know we were going to have that many fireworks before our meeting tonight, but
Yeah.
wow.
They're so excited to get the administrator's report. Set them off there. Okay.
Item
Member
one.
Wolf, I don't know if you heard that. It sounded like a cannon.
Item one is the upcoming tentative hearing schedule for the remainder of July, all of August, and all of September.
Okay, so a slight change from what we discussed last time. EOT will in fact be meeting on July 22nd. For the EOT, please make sure that anything currently pending that was not actual amendments, but any compliance issues that was going to CAC, please make sure that goes on EOT going forward until I otherwise say so. So, for example, the Rousseau case, that should go to that EOT. EOT may also want to take up, if you could work with Member Highland, who chairs that, the issue of the training we went through. I think we talked about that, and we were concerned some of those questions weren't exactly giving us.
And we talked about that earlier tonight.
Yeah, we talked about it. So I think that discussion is going to happen at EOT. So there's that. I also see, as we get into not to jump the gun, but there's a lot of initial complaints. It looks like they've recently come in. So maybe that could be divvied up somewhere between EOT and complaints. So in any event, there's plenty of work for EOT to do. If for some reason someone isn't available on July 22nd, let me know. There's a fairly good chance I can be available for it to fill in. So we shouldn't be canceling just because a member can't make it. And to that point, CAC is going to really focus on their amendment work.
Yes, and I'll have more to say when we get to them.
And we'll have more. Okay, perfect. So,
And I am available on the 22nd. Member Kumar, you're around?
I know.
You're
yes,
not
use
available.
it.
Okay, so then you're.
I'm available. You're available.
Okay.
I don't know if Member Highland is because he had to leave for an emergency. We can kind of work on it.
It's a volunteer him.
Is that?
Highland's going to be there. Yeah, yeah.
All right,
So
let's make it happen.
So I think at a minimum, you and I can be there. So that's two. That's quorum. So we'll make it work.
And there's plenty to do at complaint.
Right. So we'll find something to do. So everything else looks okay. Member Kumar, you're not going to be here for the 6th either, correct? For the August meeting. I think the rest of us are largely planning to be here for the 6th, but we're missing some people. So that looks good, I think, for the rest of the calendar. Any other comments on the calendar? Okay. Turn it back over to you, Mr. Peterson.
Moving to item 2, table shows a list of complaints received since the June 4 meeting. There are a number of matters from the same complainants. And I want to request confirmation of how to proceed when there are existing and new complaints from the same individual. Are we proceeding with 2 items per meeting?
It should be 2. That's unless for some reason when you consult with the chair that they feel it needs to be more, and I believe the task force, or I don't recall, I think it's the task force or the chair could make an exception to that. But unless there's some overriding need, we should really limit it to 2 so that one individual is not blocking others from having access to having their cases heard.
Okay. And we are working on reviewing each of the complaints to make sure that there is an overlap to try and reduce any number that we can.
2 things on that.
Yes.
I mean, if the translation of that is that Petrellis gets 2 at complaint, is that what I'm sort of hearing?
Yes.
Okay. I'm open to taking another 2 at EOT if that works.
Right. We'll kind of see how it plays
Okay.
out, but
All right.
they shouldn't take any more
Because I
than
don't-
2 it.
That's fair.
So it's possibly more than 2 per month.
Potentially, but I don't think we're going to guarantee that.
Okay.
And depending on resources. I mean,
Depending on
if there-
resources,
if that's all there is, then yeah. On 25054, I presume that's Supervisor Mahmood and Board of Supervisors. And I just, Commission and Board of Trustees, it's the War Memorial, all right, whatever, it doesn't matter. And I presume that all of these matters have already been sent to the department or respondent?
No,
No. Because?
because the notice of having received the complaint hasn't been sent yet. And I will be.
I'm sorry,
Are you saying the notice to respondent that a complaint had been filed?
yeah, my understanding is that we've got two notice things that when a complaint is filed and perfected, that we send it out to the department or respondent and say, we've got this complaint, please do something. And then when it's scheduled at a committee, then we send a notice that it's going to be at a committee if you've got anything further, blah, blah, blah. Am I misunderstanding that?
That's what I thought the process was.
That's right.
Okay. So I was asking if we've at least sent all of these in the first instance to the department, not necessarily scheduling it for a hearing, but at least letting them know that they're in.
No, they have not gone to each of the departments.
Why not? I guess it'd be the question. Did they just come in or?
They have come in. I haven't reviewed them. I haven't sent them. I will.
Okay.
So,
I mean, when they submit them starts the 45-day clock.
Yes.
So I don't know because there's no date when they came in, but it shouldn't be more than a handful of days, I would imagine, at most.
I don't want to take too much time on this, but I'm just noting the calendar. If we're on July 2nd now, and if complaint is meeting on July 15th, even if we send something out tomorrow morning, which we've got a lot of things happen tomorrow morning, the July 15th agenda for complaint gets finalized a week from tomorrow, and material would need to be in by next week, and that's going to give respondents very little time to prepare if they didn't even know that something was hitting them. So I think I don't know what else to say.
Have any notices gone out?
Yes, they have.
Okay, so it's not necessarily all of these haven't gone out. We'll just do our best to work through with what has gone out.
And if we can just reinforce that when something comes in, that it comes in, goes out. All right, I've said it.
Noted, Chair Yankee.
Okay, let's move on to part 3.
Item 3 is pending petitions and complaints before the task force and its committees, and then a tally of the items that were on the agenda for this evening.
Okay, I think we're largely working through this. It looks like the Carnesies complaints are the ones from 2021, so that'll be at least those waiting initial committee hearing. We should be able to get through that and figure that out very shortly. I think it's like a manageable load. I'm not concerned. Any questions?
So we're going to try another. We talked about that earlier, so
Yes,
that's in the works.
That's in the works. We talked about that.
Moving down to the 2023 line. Still awaiting full task force hearing on 2023 complaints. Could we either get those scheduled next month, or can we
I don't
get?
know what those are. So
We sometimes it's the petitioner.
Right, I'm saying, can we either get those scheduled or get a footnote as to what's happening with those? I'm starting to get concerned about stuff from 2 years ago. Sorry about that.
yeah, I think the general advice would be, Administrator Peterson, if there's anything that's definitely 2 or more years, which would fall into 23, 22, 21, if we could footnote why that's still there. And maybe that straggler from 2024 that's waiting a full hearing.
Items 11 and 12 were on tonight's agenda.
Okay.
Oh, okay.
And the pending follow-up? Can you
Yeah.
remind me again? What is that?
I have to do some research and
Okay.
disambiguate these cases from other cases.
Okay, fine. Yeah. That's why okay, I'm good with section 3. Thank you.
Okay, moving on.
Yeah, were there questions about the footnote?
About the what?
No.
Footnote. Okay, thank you. Item number 4 on attendance. This is a list of the last 12 regular meetings and the attendance records that we have, if there are any corrections.
Yeah, the only correction I would make, Administrator Peterson, is it's a 12-month period, not 12 meeting period. So this appears to indicate that some people may be coming closer to their limits. So for instance, if this was July, we should really only be going back to last July, which obviously there wasn't a meeting. So for example, the April, May, and June 2024 meetings should drop off. Does that make sense?
And
It's a
count on
rolling 12-month period.
12 months, but counting or reporting only regular meetings.
Right. So if let's say a meeting got canceled, it doesn't mean that we go and go back 13 months. It just means that
Okay.
gets deleted. Right. So there might not necessarily, the 12-month period may not necessarily have 12 entries. It may actually be less than.
Okay.
Yeah, that's all.
And we received one communication in this last month, and the actual article that is referenced in the email is not included because I don't have a subscription to the Chronicle.
But the link is here and that's cool.
I can't understand that the city doesn't have a general subscription for all departments to the Chronicle.
They're probably not required to.
But I'm sure the PIO in the clerk's office has them.
Let's not take time on this discussion
No,
right now. This is not the time. We need to move.
I understand. I had one other item in terms of workload.
Okay, go ahead.
And-
It's not related to.
It's not related to the Chronicle. It occurs to me the last time we had the supervisor of records report, it was calendar year 23. Could we maybe try to jog them about getting the calendar year 2024 report, since now we're halfway through 2025 and we talked about having that be earlier in the year?
Is that something you could do, Administrator Peterson, is follow up with city attorney and see when we will be getting their annual report for supervisor of records? I think it's also informative for some of the potential amendments we might want to consider making as far as supervisor of records is concerned. I think it's helpful to have that.
This isn't a tomorrow morning thing. This is a sometime after everything else.
Yes,
Thanks.
Chair Yankee, I will
Thank you.
contact the office and find out the status of the annual report of the,
Oh, and I'm sorry. The action that we took last month on the zoo letter, did a zoo letter go out?
I know Member Wolf crafted one because I worked with them on it and it looked good.
the letter's been submitted for review, as it will be on letterhead.
How long ago was it submitted for review?
I've done 2 follow-ups, one per week. I have one scheduled again for, well, it would have been Friday.
Okay, so maybe can you inform the task force members who may not be familiar with this process what submitted for review means?
Items that are on Sunshine Ordinance letterhead require the review and approval of Madam Clerk, Angela Calvillo. And that has been submitted. And letterhead has been reviewed. And now I'm awaiting signature.
Signature from?
Sign off on approval from Madam Clerk so that the letter can be signed by a task force member and sent.
How long has this?
It will be 3 weeks on Friday.
Okay, so we submitted a draft, just so
Yeah.
task force is aware of how this is. Essentially, 3 weeks ago, we submitted a letter that was completed, reviewed by us, how we authorized per our motion, and is now 3 weeks into a review process by the clerk's office with.
For what purpose?
I'm sorry?
I'm sorry, what's the purpose of this? What is the purpose of the review?
The purpose of the review, Madam Clerk approves anything that goes out on letterhead.
Has anything ever been rejected?
Not in my tenure.
I mean,
So not in the last 10 months.
I've never had anything rejected.
but it has taken considerable time at points. I would assume.
I've never heard of such a review.
Yeah, this has been an ongoing thing.
Did this policy arise because there was a problem?
I don't know.
Okay. You're right about the time. I was only inquiring about the content of the letter. My request for next month's administrator's report is if the letter has been sent, can we have a copy of the letter as an attachment in the administrator's report? And can we have some follow-up on this review process? And maybe we can talk about it then. I don't want to do any more about it now unless others want to.
Can I have clarification on what the nature of the follow-up on the review process is?
I think that would be helpful for the full task force to know what expectations, if we approve a communication, what timelines we're looking at. I just think that's part of the transparency that should exist. I don't know if anyone differs in their opinion, but
No, I agree. I think we need to know.
yeah. And I'll say that I think it was yesterday that Tanya Peterson, who's the executive director, CEO, whatever, announced her impending retirement resignation from the zoo. So this is a quickly changing situation that I think if we're weighing in on, and I know we've already been looped in on communications from Rec Park and their general manager with issues that they've had with the ongoing board audit. And I believe the board's now suspended some funding for the zoo. I think this is timely, and I think delaying it by 3 weeks or more puts us behind the news cycle as this goes up instead of being part of the solution. So.
Chair Yankee,
Yes.
The easiest thing would be, do things need to be on letterhead, or can you just send emails?
Well, right. And I think perhaps I'm tempted to agendize this particular item to see if this is going to delay our work.
Mhm.
What mechanisms do we have? I mean, could we just put our own letterhead and send it from our own thing? I mean,
It's a good question.
right.
Yep.
So we'll explore that. I think that's a great point.
You've received no memos of a change in process or policy?
No, my understanding is it's not as much the letterhead, it's the sending out from the SOTF at sfgov.org.
Again, I don't want to get into this more. We've got a couple more items. It's late and all of that, but let's leave it where we did.
Chair Yankee, I'll
Yeah.
get clarification on that.
Yeah, let's see. Yeah, we'll try to work on that.
Not tomorrow morning.
Okay.
Public comment.
Let's see public comment on the administrator's report, and then we'll move along.
Anyone wishing to make public comment on item 6, please approach the podium. And we have no one in the online community.
Okay. Let's move on to item number 16.
Item 16, hearing on Board of Supervisors, file number 250630, and city reporting requirements. Discuss and consider taking action to provide feedback on a proposed ordinance amending the administrative, environment, health, labor and employment, park, planning, police, public works, subdivision, transportation, and building inspection commission codes to modify various reporting requirements.
Okay, this is something that member Pilpel asked to be on the agenda, so I will turn it over to him.
Thanks. And please don't ask me how this got on letterhead, because I don't have letterhead, so I didn't do it. Anyway, hopefully you had a chance to read this. It's brief. I did ask to be included the 8-page legislative digest of a 351-page ordinance, and I think not to belabor the point, but that this does all kinds of things. It's a massive ordinance. It was apparently introduced by the city attorney, not a department, not the mayor, not the city administrator, the city attorney. And I just think that this is too much, too big, and deletes and revokes all kinds of things. And it would be more appropriate to review each particular fund, program, entity, reference, whatever, and decide to keep it or toss it. But this kind of omnibus thing is not a good approach. And in as much as it eliminates a number of reporting requirements, I thought that was bad for Sunshine and bad for records requests, and might likely result in more records requests for things that people kind of want to know, need to know, and that there hasn't been any demonstrated reason why to discontinue some of these things. So I put this together. I was prepared to authorize a communication to the board expressing the view that I just did and is kind of in the memo. I'm now concerned about this review process such that, you know, if we authorize a communication, that it might get hung up for 3 weeks and the board could have a hearing on it in the meantime. So anyway, I'm happy to take questions. I think it would be useful to send a communication expressing this view, but others may want to know more or have a different perspective on how to proceed. Hopefully people are still awake. Anybody?
I found it's well written. Like your preamble to this concerns me for sure. I think we should address it.
I have a question. I mean, I will agree with Member Wolf. Do you know what others think?
Others.
Meaning, have you talked to other, do you know what other people think of this plan?
I've heard from a couple of folks within the city, again, that it's kind of big, that it's broad brush, that there may well be programs and references that ought to be reviewed or deleted or have been superseded and whatnot. There are occasional pieces of cleanup legislation from the city attorney that accomplish that sort of thing, but that it is unusual, according to the folks that I've spoken to delete this many reporting requirements in the same legislation that otherwise achieves this kind of blanket cleanup. And that was the thing that I was most concerned about. Not that we shouldn't do the occasional cleanup, but you know, it's almost like finding something buried in what do you call it, the federal big bad bill that's could well have been approved while we were meeting today. I don't know. I'm sure in a 940-page, you know, federal bill, there's all kinds of things tacked in. That was the kind of thing that I think this leads to, and that's why I thought, you know, breaking it down in other ways would be useful. Anyway, I'm sure there are ways to communicate that to the board, and this was frankly part of my view that if we're going to improve the view of the task force in the city, it's that we do more, and I think perhaps a lot more than just process complaints, that we've got to be more active in terms of policy and legislation, and this is absolutely that. So it's definitely that.
Mr. Chair. Yep. Yeah, so I just in my community work, I've heard through the grapevine that the mayor has told a number of departments that for certain, well, the city calls them contracts, but if you receive a grant Anything below like, I don't know, it's like $500,000 or something like that per year won't require a full-blown report or review. Things like that to try and reduce the amount of staff time on some of the reviews of more trivial items. So he's calling it streamlining, as I think member Pilpel has noted in his letter, but it's the name of the ordinance. So just to let you know that some of it's already been implemented.
And there are other efforts underway in terms of permit streamlining, in terms of commission streamlining.
Right.
Streamlining is kind of like the buzzword du jour. And some of it is not bad and useful. It just depends on what and how. And so that was the sentiment here. I don't want to dwell on this. We only have 6 members present. If people are with it, then we can make a motion to authorize this and try to make it happen in the next few weeks. And if anyone objects, then we can put it off. Anybody?
Well, the only question I have, and I think you may have sussed it out in your preamble, is how does it specifically apply to Sunshine?
The answer is it doesn't specifically apply to Sunshine. I just think that certain reports and reporting requirements that are now in code, if they're no longer required and reported, that people who care about those things will end up filing Sunshine or public records requests, in some cases IDRs, to get that information on a timely basis that otherwise would be regularly produced by the city. It's hard to say more specifically because these requirements are in all kinds of codes in all kinds of buried little sections.
But won't the result be that those reports won't exist?
They won't necessarily exist in the way that they now exist, but the underlying data may be available and may have to be disclosed by departments or summarized in ways that they're already doing. And so it's not like they're going to save money by not producing this report.
Got it. Okay.
And again, it varies depending on the specific report. Member Wolf, since I've been on most of these motions, would you like to move to authorize this one?
Yeah, I'll move it.
Okay, so there's a motion by Member Wolf to authorize a letter as proposed in item 16. We have a second on that.
Somebody other than me?
I'll second.
Okay, seconded by Member LaHood. Any public comment on that?
Anyone wishing to make public comment on item 16, please approach the podium at this time. We have no one in the online community.
Okay, and no one at the podium. We'll go ahead and close public comment. Take a vote on that motion.
Taking the vote on item 16, Member Wolf.
Aye.
Member Wolf, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Sugarman.
Absent.
And,
At 9:34.
oh, I have that. Thank you.
Yep.
Member Kumar.
Yes.
Member Kumar, aye. Member Anderson, absent. Member Highland, absent. Member Pilpel.
Aye.
Member Pilpel, aye. Vice Chair Stein, absent. Chair Yankee.
Aye.
Chair Yankee, aye. 4 absent, 6 ayes.
Okay, that motion passes. We can move on to item number 17.
Thank you.
So,
Let's wait for the reading the
right.
record.
Sorry.
You're so excited.
Item 17, hearing on sunshine ordinance amendments discussion regarding amendments to the Sunshine Ordinance and potential action to guide the related work of the Compliance and Amendments Committee.
No, Member LaHood.
Okay, so here's what we're gonna do. We, Compliance and Amendments Committee had been hoping to schedule some additional meetings to continue our review of the ordinance. It turns out that is not going to be possible. So we're going to take this opportunity to shift the way that we're working. What I'd like to do is to ask members of Compliance and Amendments, and I know we have members Pilpel and Wolf here, and I will communicate this to Member Anderson. I had asked Ms. Peterson to attach to the agenda the latest version of the working document with our annotations. What I would like to ask of you, since we are not going to be able to use the EOTC time slot meeting, and we are not going to be able to meet again as a committee until August, I would ask that each of you review and annotate the sections of the amendment, and I mean all of them that we have not reviewed together. So that would be, we did not do 67-1 through 67, I think it was 7-9, because we started with 67-8. So if you could get those ones at the beginning, which I think were, those should be easier ones. And then everything at the end, starting with
29-2.
Looks like, actually, no, 67 20.28.
But we talked about that.
We did talk about that. I mean,
All right, anyway. to get
anyways, yes.
The beginning and the end.
Yes. To get the beginning and the end, and if you could all annotate those sections. Now I realize I gave this to you in a PDF, but I think I could either send to Ms. Peterson the Word document so that you would have that, or if you want to make your own version and then submit them back to her in time to make sure that this will be attached to the August full task force agenda. That way we are doing everything in public. We are not deliberating independently, but you're submitting that. That will be attached to the agenda. I will take all of that, try some sort of synthesis of all of those versions to present to you at our next CAC meeting in August. That is my best attempt at moving things forward if we are only going to be able to meet every other month.
So you understand that? You seem a little confused. So Administrator Peterson, what Member LaHood was proposing is that she's going to get a collection of annotations from the other members of CAC.
Yeah.
We have this as a running item on our task force.
Mhm.
Full task force. Full task force meets always prior to CAC.
Right.
Right. So you'll put everyone in CAC's annotations as part of the attachment. That gives members of the public the time between our full task force meeting in which they're proposed
Right.
and Member LaHood's consolidated version that she proposes at CAC, time to review and provide input on it.
Right.
We're trying
So-
to do this in stages.
Right, we're doing this in stages in public. And the reason we were trying to do it live in meetings was, and, taking lots of public comment was so that we could have public participation. Since we're not going to have the time to do that in meetings, we're going to do it asynchronously through the agendas of the full task force and CAC. Otherwise, it's going to take us too long and we're not going to get the work done.
Okay, and the objective is still to
Get it done
something for the
fast.
task force
Yeah.
for the September meeting. Is that still?
Well,
the
no.
goal?
So I think when I was talking to Member LaHood, I think we need to have something before the full task force, a final version, not necessarily for the task force to approve, but
No,
for us to
to
at least-
look at.
to look at and start our, full review process by, if you could do it after your October meeting, that would give us, or because it's August, October.
Yeah,
October,
logistically,
right.
if I'm only going to get annotations from everyone at the beginning of August, then we're going to have a full CAC meeting at the end of August. I mean, I don't think I'll actually have time to get it to you for the September agenda. So, I mean, what I can
Maybe
I
you
can
could,
try, but
and it depends whether or not even all of you can come to a full agreement. You might need
Right.
another go around in October, and I think that's okay. As long as we can have it before the full task force by our November meeting, that would give us November, December, January, if we work diligently, and we would, I think no later than January, because that's early January, have to pass something out to send to the board.
And I think what we're going to do is actually present two things. There will be a fully annotated ordinance, and then there's going to be a wish list that is going to be short and succinct and independent of all of the line editing. Since we've gone through this work, we want to do the line editing. We want to synthesize this along with, feedback that we've gotten from members of the public and do our best to integrate it all in one draft. But we understand that it might not be possible to come to total agreement on that, but we think that we as a committee, and we hope that the full task force can come to an agreement on a list of however many, these are top priority things that we think need to change.
Kind of like the needs versus the wants.
The needs versus the wants, yes.
I think that's a fantastic idea.
Yeah, and I'd love to hear what people think, especially Member Wolf, since I'm volunteering him to participate in this scheme, since we're not going to be able to have the extra meetings that we wanted.
Yeah, that's fine.
Okay.
So, sorry, I keep thinking of the big bad bill. I think this is like the Votorama part of it.
Yeah.
And I think what you just highlighted was what I think of as the big fix, which includes all the edits,
right,
versus the big five, which is like, what do we absolutely need to get in order for this to be worth doing?
Right. Or it might be the big 12 or the big 20.
The big five
yeah,
may become 12, right? But the stuff for which there's broad consensus and still allows us to do a more technical cleanup fix.
We can have
in the
tiers.
future.
Yeah.
Yes. Oh, there will be plenty of tiers.
Well, I meant the other kind, but yes.
Oh, okay. Yes.
Yes.
All right. So that gives Member Wolf, the three of us and Member Anderson work to do before the end of the month. And perhaps we can, at our August full task force meeting, discuss where we're at on this project and have yet another update. I mean, this
right.
progress.
And the thing is, by having it on the full task force agenda, it does create opportunities to get public input. Although if we always do it at the end, I don't know that anybody's going to stick around, but perhaps, maybe not.
They can even submit it in writing.
They can submit it in writing. Actually, that's a good point.
Yep.
And maybe we could even put that on the agenda.
Yeah, it'd be just like we do with the
welcome-
annual report.
Yes.
When
exactly.
Vice Chair Stein did that, she had a contact.
Yeah, yeah,
We could even just use the generic SOTF one, and then she could forward that over to CAC.
exactly. So,
Okay. So there are lots of ways that people can
Participate.
engage, and we're moving this along.
Any particular action items or topics you wanted direction from those of us who are here on?
I mean, the big thing was actually to communicate to the committee members about what I need from them. But we always welcome, again, any feedback from any task force members who have noticed things coming up again and again, or had revelations that they would like us to consider about how to improve the ordinance.
I mean, the only real two quick things. Number one, I think obviously take into account some of the ethics issues that are ongoing and how we can, rework that, since I think that's part of the ordinance you guys haven't gotten to yet. And then number two, I think the other things we have to start exploring, for all the good work that we're doing, we want to make sure it actually has a viable path to get there. So if any member of the task force knows contacts at the board, their own board member, another board member they've worked with before, we want to make sure we can get, there's a variety of ways it can get on the ballot, the mayor, so forth and so on. And so I think it's time we start taking that portion seriously as well, because I don't think we want to end up having done all this work by the end of the year and then having no one really interested in taking it over the line and get down the ballot.
I would just add to that, Member LaHood, if you didn't get a chance to listen to the end of the June meeting.
Oh, I did.
Okay, and that's where we had some good,
Yeah.
good stuff. And I agree, other than those topics that we had last month, I think this question of enforcement and our relationship with ethics and others, like when you get to the end of the thing, how do we enforce it? I don't have a good answer to that. I don't know that anyone has a good or a great answer, but ideas that we can hone in the next few months about what works better than not
Yeah, and let
Would
me
be
ask, we do have our DCA here, not that I would expect the DCA to show up at the CAC meeting, but nonetheless, is it something that the DCAs could potentially assist us with on exploring what viable enforcement options we may have that aren't necessarily written in the ordinance right now, but perhaps other city agencies or bodies that work in a similar capacity to us might use?
Yeah, I can definitely look into that.
That would be terrific. And then we would maybe
Thank
use
you.
that as a grab bag of ideas.
Yeah.
And feel free to noodle that around with the team and however you guys can.
Yeah.
Yeah.
Okay, I think we're good on that. Let's go ahead and
Thank you.
check in on public comment.
Anyone wishing to make public comment on item 17, please approach the podium at this time. We have no one online.
And see no one at the podium, we'll go ahead and close public comment and move to item 18.
Item 18,
No action.
announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay, anyone have anything for item 18?
I did it all.
Okay, going once, twice. Okay, nothing. Since we presented nothing, there's no public comment to be taken. No action on item 18, and we will move to item 19.
Without
Item 19.
objection.
Okay.
Item 19, adjournment.
Time of adjournment is 10:16 p.m. without objection.
Thank you.
Meeting is adjourned at 10:16. Microphones are off.
Good night, all.